So I beg to mention, item number 46 with the concern of the other side lordship. Can it be 46? Can it be next week lordship? I supposed to file an affidavit lordship. I send it for vetting lordship.
On 27th, your lordship, next week.
27th is the last day.
Then 30th of day after next week, your lordship.
So CEO is out of business also. Some time
Will
is
it be in July? Reopening?
It will be too late. So they are supposed to file their additional affidavit, your lordship, with regard to para 8 and 9.
What is the matter about?
matter regarding the MSCP benefit of the petitioner lordship. I send the affidavit for vetting lordship.
The benefits, your lordship, they have admitted.
You have retired.
Not
Already
retired,
he
your
take the
lordship.
VS.
VRS has been granted, provided, your lordship, when I filed this writ petition, they filed a counter affidavit after repeated, your
Will
lordship.
it be in July?
Lordship.
They have taken their stand, your lordship. That we are
Already
entitled to
accept
receive
the
the benefit,
money,
your lordship. They have taken their stance in their counter affidavit.
What is your urgency that it has to be done in June?
So they have released the VRS 50%, your lordship.
They'll release it.
Based on that benefits, your lordship. Otherwise, your lordship will
That's
suffer.
right. It release it. We are not rejecting your claim.
Yes, yes.
You want the matter to be on 27th. That's the last day.
In July lordship.
Date may be fixed. After you
18 July. 16 July.
Okay, obliged.
Obliged.
16 July, the request made by Council for the Marketing Board. Item 46.
46. Obliged.
Item number 31, I am paying adjournment for a week now.
Item 31 stands heard to be summer vacation.
Lordship, I beg to mention item 37 of today's daily list. In this matter, Lordship, the respondent number 3 has filed an affidavit in opposition. I need to file a reply to that. So at least 3 weeks maybe.
Rejoin the affidavit filed by the
Lordship, if possible, a date may kindly be fixed. Immediately after.
matter be listed in the 4th week of July on a date to be fixed by the region.
Obliged.
That is the item 40, your lordship, 40. Item 40.
40.
Yeah. But in this matter, your lordship, Mr. Medhi, it seems, is not available. So,
Lordship, I would beg to mention item 40 to file affidavit in reply. More 3 weeks
You are for whom?
for the respondents.
You want to file a reply.
Affidavit in
we
reply.
have filed an additional affidavit. They have already sought time to file a counter. It is not yet filed. Your lordship can fix it.
Item 40 as a request made on behalf of Mr. S.K. Medhi, matter can referred to be listed in the month of August. 4th of August.
Can it be in July or 21st of July or 23rd?
Or 23rd of
Lot. Yes.
23rd of
Obliged.
Yes.
But I would to mention item number 20, Miller.
20.
20, Miller. The matter will kindly pass out for the day, Miller.
Why?
I have some personal difficulty, Miller.
Item 20.
20, Miller.
Matters can pass for the request made by Mr. S.K.
Right.
Lordship, WPC 1910 and 1899. These matters were earlier listed in 13.6.
Listing of matters, court number 5.
Lordship, this matter was earlier listed in this court, but it's supposed to come today, but it is not in the
Listing
list.
of matters in court number 5. When matters in court number 5.
In this matter, they filed affidavit in opposition. We need some time to file a reply, Lord.
Reply. I think there is some.
Yes. Lordship, may kindly pass on the matter of time being. Learned AG is appearing in this matter, is on Lakes Melon. He's coming, man.
Reply is required to be filed.
Lordship, may
We were under the impression, perhaps, Lordship, only the minutes be brought on record, but they have answered parawise. So I have consulted.
Where are the minutes?
minutes is Lordship annex of 4, my lord. Lordship, kindly make a pass over time being. Learned AG is coming, my lord. He lakes in the room. Page 75, my lord.
Page 75.
Of the
Our affidavit filed by the department, my lord.
affidavit filed by respondent 2.
2, Lordship.
Annexure.
Annexure 4, page 75, my lord. Relevant is 76.
It is done already.
They have answered pairwise also to the repetition. So I have consulted with my client, let it come after a week, any day, Lordship. My client wishes to have a,
Next week,
Lord,
the request made by the council. With respect of the minutes of the meeting held between the State IWD Employees Association, former Managing Director AIWPL, Director IW on 4/4/2025. The Commanding Council believes that the listed after 1 week enabling it's again
Lord,
it is
26.
Lordship, AG is coming in.
We are fixing
Plus
the matter, we are
26.
not disposing it off. Inform him that
My lord,
26,
oblige,
yes,
is
we are
coming.
taking up on 26.
26, not the Lordship. Otherwise, the case is actually it is in flux was.
He seeks some time for instructions in
Definitely he should.
26th
Lordship.
June.
Highly obliged.
Please, your lordship. So this is an application for appointment of an arbitrator. My lord, I have got on record the NIT containing the arbitration clause. My lord.
Where is the agreement?
Agreement I have annexed in page 26, my lord, of the arbitration petition. Yes, sir, lordship, page 17. It was the agreement dated 29 March 2016. my lord. And I am relying on clause 1.2B, my lord.
1 point.
1.2B, page 19, my lord. It says the terms and conditions of this agreement shall be read and interpreted in conjunction with those of the GCC. In the event of there being an inconsistency of the interpretation of the provisions of general conditions of contract and this agreement, the terms of this agreement shall take precedence, my lord. The arbitration clause, my lord, finds at page 101. 101 of the additional agreement. Four point 1.6. Settlement of disputes and arbitration.
This is a part of,
My lord.
this page 101 is the part of what?
The tender, my lord.
Tender.
Yes.
Six of the when the right by the or agreement was executed by an agreement. Was it terminated? Was it-
I have issued determination, my lord.
You have issued it?
Yes, ma'am. I have annexed it, ma'am.
You have quoted the NIT.
No, no, no. I am for the petitioner.
Ah.
I am the successful bidder, my lord.
Ah.
The NIT was floated by the respondent.
Right.
And accordingly, we have
Yes.
entered into an agreement, my lord.
You were shortlisted.
Yes, ma'am.
You entered into an agreement.
Yes.
Then what happened?
Then we have started our works, my lord. We have forwarded them various bills, but that was not paid. So we have I have annexed all the correspondences, my lord. After that, since they haven't replied, my lord, I have forwarded the notice for appointment of an arbitrator. Then I have forwarded the terminator.
The person who the petitioner being shortlisted, the proceeding, the work. However, the bill raised is not paid by the for it. Leading to disputes between the petitioner thereafter issued for appointment of an arbitrator. The response of the clause 4.16. So, see, any response to your notice?
No, ma'am.
Para issue notice. We can report it. Here, do you want to take custody also?
Yes, my lord. You can take it.
Custody, put it to the registry of the court. This after.
Wait, Your Honor. This is the application number 11.6 of the Arbitration Act. Lord. The partnership be that page number 18, Lord. An arbitration clause at page 28. As certain dispute has been arose, a section 9 application was also filed wherein an injunction order has been passed.
Where is the arbitration?
Arbitration at page 28, Lord. Clause number 18.
You also have this. It's pursuant to the agreement by between the parties. 17th April. The dispute could not be resolved. The invoked the arbitration clause that for the 18th the agreement. However, it's not yield. Leading, I think. But it's definitely very good. So like it will force me. Will you take custody?
No, Lordship, the state is outside, Lordship. For the state Gwalior.
Will you still have?
Public.
Yes, my lord, seeking my lord, appointment of arbitration. It is this notice may be issued.
Where is your registration?
My lord, the arbitration clause, my lord, says 85.
85.
Says 85 of general condition of contract, my lord. Condition number 70, my lord.
And the respondent have paid the point. Arbitrator. But the notice issued by the petitioner. In clause 70 of the agreement executed by the right notice that is only. The people we have all you know, each one to be listed, the respondent will file their objection. Be listed after 4 weeks.
Obliged.
On the last occasion, court has asked what happened to the appeal. The appeal has been disposed of, Lordship, on 29th. Check, okay.
You've given him a copy,
Yes, Lordship.
then he has become infractor.
Yes.
So only thing is that there is a provision for revision not to be allowed to file.
You find. But. Reference to the earlier order dated 3005/2023. That is C. State instructed that is to the court, it be prepared by the petitioner against the orders passed by the disciplinary authority, but rejected by order dated 29/5/2023.
Take the also.
of the copy of the same as the case report is kept in the case report. And shared with the council for the member. That we use the since the appeal has already been disposed of. The writ has been filed. So that the appeal, if the writ has been filed, then we did in a direction. But you are praying for setting aside of the termination.
Lordship.
Then-
Mainly, that is our prayer, Lordship, but in the meantime, they have followed the appeal law.
The writ petition has been filed, praying for setting aside of the termination order. However, in view of the appeal, they disposed of, being rejected by the authority, the council will the court prefer. And what is the review? Revision.
Revision.
Revision before the still higher authority prescribed under the statute. So such view of the matter, if it is permitted, but revision. The closure of the writ petition shall not operate as a bar. It's a rule.
Obliged.
Please, Your Lordship. Actually, I've just been informed, we are in this matter, my lord. We have not been served any copy, my lord.
We served the copy to the government advocate, perhaps.
We have served it to the government advocate, my lord. Actually, the GAD is the main party, my lord, because they have given the representation to the GAD, my lord. If he, my lord, serves me a copy, I'll get my instructions, my lord, in the meantime.
I'll do it today itself, man. Mistake. We served in the government.
Mr. A. Pupatla, representing council GAD, submits that the direction of who represents deputy commissioner?
My lord,
He's the petitioner is agreed by the orders passed by the deputy commissioner. What has GAD got to do?
the representation he has given to the GAD.
Appeal is before the GAD, man. We filed an appeal against that.
This is a process about the grade for employee. My lord, deputy commissioner is the right person, my lord, to, my lord, is the, my lord, that discipline authority. Lord. They have to file an appeal before the deputy commissioner.
Deputy commissioner,
Lord.
not before GAD.
No, Lord.
Deputy commissioner passed the order. How can I file an appeal before the deputy commissioner, man? The
Deputy
authority which just passed the order. You can file an appeal before him, man.
Commissioner is the disciplinary authority.
Page 63, man, is the order.
Section 12.
Yes, what is the deputy commissioner?
Who has passed the order of dismissal?
Page 63, man.
Is it an appeal? The order passed by the deputy commissioner is an order in appeal.
Ministerial. Ministerial.
So this is by the disciplinary authority.
Disciplinary authority.
Section 12.
Appeal authority is deputy commissioner.
No, section 12.
No, rule 50.
So no,
But I have preferred appeal and rule 15, man. The Assam Service Discipline Appeal Rules, man. Appeal against orders imposing penalty, man. Any penalties under Rule 7, man.
you fall under which service?
My lord, military service, my lord, and I have to, my lord, therefore, my lord, I have to, my lord, file an appeal before the, my lord, GAD. Initially, I filed it before, my lord, the revenue department. My lord.
Now, what provision are you saying that your appellate authority is GAD?
My lord,
Which
the,
rule?
The rules will not specify, my lord, but then it's a schedule, my lord.
Why not
Rules-
the revenue department?
Hello?
Why not the revenue?
We
department?
file it before the revenue, they said, no, you have to go before the GAD, man. We initially filed with the revenue, man.
You are a process server under,
Well, under the circle officer, man. The circle officer, man.
so you are covered by,
Well, otherwise, the ministerial service, my lord, we are covered, my lord. Here, my lord, under the discipline appeal rules, my lord, the appellate authority is not prescribed in Rule 15, my lord. It is, my lord, under the schedule will be there, my lord. But, my lord, we have been told, my lord, since there's a Jari Kara, so that's they also admitting, my lord, it's before the General Administration Department.
Lordship, kindly have a look of the to the instruction that I have received, Lordship. Lordship, here a clarification was sought from the Deputy Commissioner, Lordship, whether he is a employee of the Revenue DM Department, Lordship. Then it has been confirmed by letter dated 13/5/25 that the appellant is an employee under the General Administration Department. This is the instruction that I have received from the Joint Secretary to the Government of Assam GAD Department, Lordship. The very first page, Lordship, in para 3, 2 and 3, Lordship. Then the next page, the confirmation letter is there, Lord.
third council to the party. Pursuant to the earlier direction of by the court,
Right, yeah.
and it happened at it, as placed before the court, written, received from the Department of General Administration or General Administration Department. That the petitioner is an employee under the General Administration Department, and therefore the appeal preferred by the petitioner has been accepted by the appellate authority, the General Administration Department. There are Mr. A. One of the other end, standing counsel representing the General Administration Department, however, submits that extra copy to the writ petition is not made pertinent, and therefore he is unable to obtain the request. Mr. Doctor has assured that he will file extra copies within 2 working days.
Today, I'll finish.
And thereafter the standing counsel list again. The respondent in the meantime may also. Have we issued notice?
No, my lord.
No, Lordship, notice not issued.
We issue notice?
No, should they dispose of parasite? No, this, since if they dispose the appeal, my lord. My
Yes,
prayer is that
Lordship.
they should dispose of the appeal, my lord. This is a statutory appeal, my lord, that has to be disposed of.
I mean, he has no instruction.
No, Lordship,
Let it-
kindly peruse the last page of the instruction, Lordship.
First page.
Last page, page number 3, Lordship.
Yes.
Lordship, it is a communication, Lordship, from Joint Secretary to the Deputy District Commissioner, Kamrup, Lordship. They have sought for some this thing, instruction from the Deputy Commissioner, where I was reply to the appeal, Lordship. And most probably they, after receipt of this, they will be disposing the appeal, Lordship.
So therefore, we'll have to give them some time to
Yes.
give instructions.
Lordship.
Let me be next week.
Huh?
Let me next week.
No, Lordship, on the reopening, Lordship.
Maybe after reopening.
Yes,
then we
Lord.
can come with proper instructions.
Yes, Lordship.
He's will retiring in September. That's the reason.
September, then what
We'll have
happened,
to
Lordship?
apply.
In July, it
Lordship, our name may be reflected by.
No, name may not be reflected. You note down, we'll fix a date, you appear on that date.
Fine.
To be fixed again. 21st of July,
Smile.
Lordship.
Apologize.
enabling the respondents to give their instructions. Registry will endeavor to reflect the names of all counts. You note down 21st.
Deeply obliged, Lord.
I'm for the petition number. It's my application under section 11 for appointment, 11 of the Arbitration Conciliation Act, my lord. For appointment of the arbitrator.
Where is the agreement?
But
Is the
if your
clause?
lordship kindly comes to page 121. That is the arbitration clause in the agreement, my lord. And my lord, agreement starts from page 50.
Yes.
Clause 64(1), my lord, which refers that this clause of GCC will be the clause for arbitration, which has been enumerated in the agreement.
Yes. For the respondent,
But
it's the railways.
railways, man, we have already served.
You're Mr.
Shayok Ranjan Ganguly.
Yes, sir. Okay. The petitioner had entered into contract agreement with the NFDP. Pursuant to which, pursuant to what of the contract for execution of the work by the- by the. What happened after the contract is awarded? What happened after the contract was awarded?
After that, my lord,
Did you get to execute the work or?
we have executed the work. They have deducted liquidated damages from my bill on the ground that I could not perform the terms of the contract within the stipulated time period.
The
on-
work was duly executed, however, the respondents to deduct liquidated damages on the ground that the work could not be completed within the specified time. Being agreed, the petitioner demanded as is provided for under law code. Any arbitrators appointed? No,
No, my lord.
they did not respond.
They did not respond, my lord, even after issuance of this section 21 notice. But my lord, if your lordship kindly comes to their letter, which is at my lord, page 3. Yes, my lord, page 323. In terms of the GCC, my lord, we have prayed for mediation. They have refused. They have rejected my prayer. Wherein, my lord, they have advised that you go for arbitration.
But they did not.
My lord, paragraph
the
2, my lord.
notice of. They did. Section 11. The- Step to the bottom by April Court registered post. 80. To be fixed after 4 weeks. You want to take custody?
No, my lord, I will serve it through post. My lord, may I pray for only one indulgence, since I am not locally stationed here, my lord. If a date may be fixed, subject to convenience of your lord.
It will be in July
July, is it possible, my lord, on 24th of July?
24th.
24th.
24th may not be possible. We can give you 23rd or 25th.
23rd? My lord, 23rd time.
23rd July. It's not-
March of like.
The card for respondents have been awaited.
Yes, Lord. Respondent number 5, the service report is awaited, Lord. We may be allowed to take.
Yes,
Lordship, we haven't received any instructions, you know.
for which respondent? You're appearing for which respondent? Office note dated 10/6/2025 reflect that notice- service of notice on the 5 will be. Matter be listed up.
Myself.
Your lordship, I am appearing for respondent number 2, 3, and 4, lordship.
Hmm.
And as per the reports,
Right, none appears for the petitioner on call, none appears for
okay,
5, 55, 11. Mr.
Z Hussain,
J. Hussain,
Z,
Z. Hussain. appears
for 2, 3, and 4.
Appears that it interested in the extent that the reporter, the penny stand located at the time.
Obliged, lordship.
Please, your lord. My lord, the affidavit that was filed, which was not on record on the last occasion. My lord, I've gone through this. My lord, page number 38. They say that out of the amount of 10 lakhs odd, they have till now made a payment of 4 lakhs. But my lord, contempt perhaps is remaining because of the fact that the specific direction was for payment of
What is the direction?
the direction. Your lordship will kindly take up my contempt petition, my lord. The order is from page number 13. The operative part, your lordship will kindly see at page number 15, the last paragraph. And this is out of an admission made by them and an undertaking given by them. The direction, your lordship sees at page 7.
Yes. Well, actually, we are suffering from financial difficulties, my lord. That is why we have paid for some time, my lord. In this case, my lord, however, my lord, government has provided some guarantee aid, my lord, but that was not allowed to pay for salary remuneration.
You
Well,
are exposing yourself to concept. Will issue notice of concept.
My lord, let's see the annexure.
See, this is an order passed by the court. It is a consent order.
Yes, yes.
You have agreed that you will pay.
Yes, my lord.
You have agreed that you will pay within 6 months.
Yes, my lord.
Why did you agree that?
My lord, we are supposed to receive, my lord, government guarantee aid, my lord.
That
But-
is not reflected in the order. You have not sought for modification of this order. Not for sought for enlargement of time.
That is true, my lord, but also some time may be entered, my lord, will.
You file an application, otherwise we are issuing contempt.
Yes.
You were having it on Monday next. You decide, or we are issuing notice. We are issuing contempt. We are initiating contempt proceedings against the respondent. It's on Monday. 23rd.
Obliged, ma'am.
Take the receipt. It is the order date. Pass with the application. We are putting you to notice. You think about it, come back on Monday, tell us. If you are unable to do it, we are exercising our contempt jurisdiction against the respondent.
Obliged.
May it please, my lords? Because in item number 11, my lords, the writ petition, my lords, the affidavit has been filed on 16. It's not on record, my lord.
What about the contempt?
Until, my lords, the affidavit is ready, we've sent it. The signatures are awaited. We've filed a.
Sir D. Chaudhary appearing for the respondent. Praise for another week's time to file the affidavit with the contempt. Further submit that the writ petition, the affidavit will be filed. The history will trace out the affidavit, take it to be filed
By this respondent, my lord.
ONGC.
Yes, my lord.
By the respondent. Connected with the record. The picture of date. It was immediately after the opening date.
Deeply over.
Maybe your lordship, my lord, in this matter, I am for the petitioner in this arbitration petition, my lord, for appointment of arbitrator. But in the meantime, my lord, they have filed one IA also. But my lord, we have with the advocates, my lord, we have our party to settle the matter outside the court.
What is this I for?
I for my lord, this your lordship appointed one propose one name of the arbitrator. Against that name, my lord, they have filed one IA. This matter came up after 2 weeks, so that in the meantime they try to settle the matter outside the court, my lord, if possible.
Yes, responded.
No objection.
It is from their side also, my lord. Proposal from both sides, my lord.
Okay, sir. That there is for how the dispute outside court. Out of court.
Yes.
Is not it. He submits that to be listed after 4 weeks. Prayer made is not affected to by the it's after 4 weeks.
Obliged.
Though, as per the last order, Malad, there will be direction to an instruction regarding why there was a mismatch in 8, 9, and 19, my lord. That information, Malad, I could not gather, my lord.
And how much time more?
Malad, next week, my lord.
If you tell after vacate. After vacate.
My line frame pointed about that 8 and 9 is the code is not that. That is not in the record in writ petition affidavit as well as now in the review petition. There is no any record. How he says, my lord, and record of the, my lord, if all could permit me, my lord, the report of the person to the Honorable High Court order, my lord, they stated that 2008-9 is there. They stated, my lord, as per report, my lord, page 81, my lord, your lord.
The review petition.
Yes, my lord. Page 81, my lord.
81.
My lord. This was issued by my person to court's order. Verification was done. Serial number 2, my lord. Middle 122. Kawimari Nopoma LP School has submitted dice for the academic session 2006-7, 7-8, 8-9, 10-11, 11-12, 12-13, except 9 and 10. And 9 and 10, your lordship already decided. My lord, already contempt proceeding was drawn up, so thereby, my lord, this delay is coming. Para 11, your lordship order specific, my lord. Page 114, my lord. Para page 114. Your lordship order is very specific, my lord. 114, my lord. My lord, 11. Since the existence of the school is not in dispute and the information captured in dice code for the year from 6-7 to 12-13, except the year 2019. Therefore, the non-ability of the dice code for the year 19, reason for which cannot be attributed to the petitioner school, cannot be constituted to be a default on the part of the petitioner, disentitled the petitioner school from the benefit of provisionalization already made by the government. Matter. This is specific matter. It cannot be reviewed now, my lord. I review, my lord, I am brought to judgment, my lord. So, my lord, at this stage, my lord, on the basis of that query, my lord, my lord.
Yes, sir.
I brought into judgment your High Court as well as Supreme Court, my lord. Otherwise, my lord, the paragraph 11, my lord, in fact, in the last order, my lord, there was an observation that this will not change the direction contains in paragraph 11. In the last order, my lord, passed in this proceeding.
Last order means 28-5.
Yes, my lord. There's an observation regarding paragraph 11, my lord.
Which paragraph?
Review petition, Page 114. Last order. Last one.
Which paragraph?
My lord, last third paragraph, my lord. From the bottom, my lord, third paragraph. The learned counsel for a review petition, however, fairly submits that the conclusion arrived at by the court as reflected.
No, you're reading which order?
My lord, last order, passed in this petition, in this review petition, my lord, 28/5/2025.
All right, paragraph,
This from the bottom, this third, my lord.
second page.
Here, my lord.
You read the order?
Yeah.
You
Yes, my
read the
lord.
paragraph?
The learned counsel for a review petitioner, however, fairly submits that the conclusion arrived at by the court as reflected in paragraph 9 and 11 is based on a report conducted by the sub-inspector of schools, Kodam, and it was forwarded to the higher authorities and the record has not yet been recalled. He therefore submits that the matter be listed after 3 weeks.
Yes.
So, my lord, regarding the observation made in the paragraph 11, my lord, it will not change the observation if for the year 8 and 9 also is not there, my lord. That was the observation on the last occasion. Only 2008-9, that is there, my lord. The requirement under the 2011 Act was, my lord, to have the dice code for 2009 and 10, my lord. But here for 9 and 10, it was not there. That was the reason, though provisional order was there, but their salary will stop, my lord.
No, that we have already ordered.
Yes, yes.
Now, what is the ground for review of that order?
That is the ground, my lord. The mismatch is for 8-10 only, not only 9-10, for 8-9 also.
But 8-9 you have already in your own letter, the letter of the BEO,
Yes, my lord.
page 81.
Yes, my lord.
You have reflected that it 8-9 is there, except 9 and 10.
Yes, my lord. Though in this letter it is there, my lord, but from the record of this review petition, it is seen that it is also different, my lord.
So you get instructions and tell us, this is the instructions we wanted.
Yes, my lord, because I could not gather, my lord, due to I have communicated
You
lately, my lord.
cannot
That is
gather
why.
now, or you will not be able to gather ever.
Not the no, my lord, because I have communicated lately, my lord. That
Want
is why, my
some
lord.
time.
Yes, my lord. Next week, my lord, I can obtain, my lord. By
Next week. Next week.
Next week, Wednesday, my lord.
Next-
What?
25th.
Huh?
25th.
Yes, my lord. 25th. That 2008-9, there is no any pleadings, my lord, regarding to
The review. Order. Yes. That's what that is.
Mark.
Peruse the earlier order, Malak, 28/5. Malak, and then taking time, Malak, to receive instruction. May please your lordship, on 27/05/2025, letter was sent for instruction. Your lordship, so kindly allow us to 2 weeks time to file affidavit, our affidavit.
The to and so let the council for the response raised for the other 2 weeks time. The orders passed with the with them. Several opportunities were granted to the respondents to complete their instruction. However, prayer for completion of instruction, prayer to complete instruction is renewed. Again today. considering that the contempt of the court grants one further opportunity to complete the instruction, failing which court will proceed of the material the will court is again on 18th of July. Here, the appeal.
With regard to service, my learned friend is will enter their appearance.
Your lordship, but I need to file wakalatnama for all the parties and we
You
need some.
represent all.
Yes, your lord.
Mr.
And-
Sharma has entered here on behalf of all the respondents. He therefore submit that you'd like to complete the formality and give the instruction. 4 weeks time.
And in the meantime, your lordship, we have filed appeal against the order. It is pending before the division bench.
You read it on record.
Yes.
Mr. K. Rahman appealed for the interpretation. It's again on after 4 weeks.
Mal. May pay for a date one.
After 4 weeks, please again on 18th July.
Mal. Obliged.
Lordship, we had filed this particular IA seeking the interim order be continued, that which was unfortunately left out on an order that was passed on the 23rd of April, Lordship. It was an honest mistake on our part, Lordship.
Who's for the respondent? Where is the interim order? The writ petition.
The interim order, Lordship, is attached.
Who is for the respondent? Yes. Anything to submit? Order. He gets it. You have not gone and joined the new place for posting.
No, Lordship.
Huh?
Not yet, Lordship. Because the initial order that was
You're
passed,
violating the order of transfer.
Lordship.
You have violated the order of transfer. You are on transfer.
Yes, Lordship. That is the main order. That is what we've challenged, Lordship, in the main writ petition. The transfer order dated 20th of February 2025. Subsequent to that, Lordship, this Honorable Court had passed this interim order on the 17th of March, Lordship. And then on the 23rd of April, when the returnable date came up, this mention for the continuation of the interim order was unfortunately not made. And subsequently, on the 21st of April, the petitioner was handed this
filed
order.
the extension of the transfer order that was suspended by the court. 73/2025 while issuing the interim order, the transfer order was to remain suspended till the next date. The matter came to be listed thereafter on 23/4/2025, of which date perhaps prayer was made for extension of the interim order. They not extended. This IA has been filed seeking extension. The respondent has not filed any application indicating notification. The such circumstance, this court is of the belief that there is no intention of the order is reported by the court without there being a specific direction to that effect. This court lets the reporter take it passed by this court with the credible date. A accordingly stands with both of the writ petition. A accordingly stands allowed both of with the proof that the writ petition rejected it after 21st of July reported in the writ petition implied so orders passed in the IE. In order passed on to stated it listed on 21st of July. If the order will continue till the next day of this year.
Extremely grateful, Lordship.
Happy.
Yes.
We have filed two interview application for substitution of the respondent worksheet, but only one listed topic in respect to the item number 17. Okay, what happened in this case, worksheet, the dependency of the petition, the respondent two expired.
Respondent who expired.
Respondent.
You are filing an application
For substitution of the case legal. As respondent two, one and two.
Yes, Mr. Chakraborty.
My lord, in item number 17 and 18, I represented the deceased respondents. So, my lord, now notice has to go to the legalians. So,
We will issue notice here.
in item number 17. So, for item number 18, my lord, the substitution petition is not before your lordship.
Yes. Already numbered, Lordship. That
What is this petition?
This is in item number 17.
17.
This is,
Application for
yes,
Substitution.
substitute.
Yes.
there are two writ petitions. In both the writ petitions, so
This is filed in WPC 1104.
Yes.
yes,
That is in item 17.
17. In WPC 1102, there are the respondent number 2 has in the meantime died. So
That was also we have filed, and that
But
is
that is
also
not listed.
registered. Lordship.
Respondent, in both writ petitions, the respondent two,
yes,
same person,
no, different person.
but respondent two.
Respondent 2.
So we issue notice here.
Yes, ma'am.
Mr. K. Kolita, counsel for the applicant. Mr. S. Chakraborty, and both of you are appearing together?
No,
same
he is-
person?
no.
I am on the number 18.
You are for 18. Mr. S. Chakraborty represents, you
In
represent
fact,
whom?
I represented respondent number 2. So upon his death, I no longer hold the wakalata.
Only-
So notice
only-
has to go to the legalians, ma'am.
Only respondent two or
Respondent 2.
the S. Chakraborty had earlier represented the deceased employee, the deceased writ petitioner. Is a writ petitioner.
No, he is respondent number 2.
This is respondent in
Writ petitioner is oil in
WPT number 1104. He, however, submits that since respondent 2 had expired, he has no instructions to represent the legal aid. Therefore, notice be issued. We don't want to be. According issue notice, return in 4 weeks, steps on the legal aid of respondent number 2, date Islam, namely Tayyab Ali and Inayat Ali, by registered post dating and to be listed after 4 weeks. In Item number 18, say that counsel for the submit that an IA for substitution of ALAs of the respondent group in item 18, petition number 12 has also been filed for the same.
In ISC number 1980/2025.
Has been numbered.
Yes, Lord. ISC number 1980/2025.
However, the same is not listed. Let this item, the item number 18, be listed on Friday.
Yes.
Friday. Yes.
Yes.
Made list. Lordship, in this matter, we have received the priors from his lordship, so we therefore filing the affidavit lordship in the
None appears to the petitioner. So, okay, what? It's that with the magic listed 4 weeks.
possible.
It with the respondents to file the amendment.
Here I was supposed to file the affidavit. In the course of the day, it will be filed. By 1 o'clock or 2, I will get the affidavit.
The IA for
My lord, I for praying for a release of the petitioner's salary. The petitioner was ousted from his cadre and he filed the accompanying writ petition wherein this honorable court stayed the transfer order. Option to that, he has not been paid salary. In fact, they have filed a counter affidavit to the IA wherein they said that I'm not working. I have filed an additional affidavit to bring on record to say how systematically they have ousted me from the roster even, my lord, duty roster. There is a stay order operating, they are not paying my salary.
Let us file the affidavit, my lord. These are factual disputes, my lord. We'll clarify everything in the affidavit. By today, it will be filed.
the challenge is to what?
Yeah, the challenge is a transfer order.
Transfer order.
And that has been stayed. He has been transferred from the State Cancer Institute to Jorat Medical College.
That is state.
That has been temporarily stayed.
So you have to release his salary.
No, my lord, our allegation is that he has not been rendering his duty despite having the stay order.
He is not rendered, you proceed departmentally. How can you withhold his salary without any proceeding?
No, but my lord, if he has not joined, my lord, or he has not rendered his service, how he will be entitled for salary? Despite having his stay, my lord.
No, if he is not entered,
my lord.
where is the question of transferring? You transferred him from his existing post.
Yes.
That was state.
Lordship.
So if he is not rendering service in his present place of posting, so proceedings or whatever available mode,
Lordship.
can you withhold the salary?
Since my lord, there is nothing to show that my lord is rendering. So my lord, the authorities are not released. That's the ground, my lord. Lordship will consider it when later affidavit be filed.
A cadre officer as if he is a daily wage worker. How can that? If he is not working,
my lord,
you are entitled to drop proceedings.
In fact, one proceeding has been drawn, my lord. It is a challenge, my lord. That's charge memo. It's in court number 5.
Whatever it may be,
Okay.
but can you withhold the salary like that?
Withhold, my lord, it's not about withholding, my lord. Let me
Is there any provision of the law to say that you should not release his salary if it doesn't work?
No work, no pay, my lord. Of course, my lord.
Work, no
Person.
basis of some finding.
Yes.
So to find
No, that part, my lord, now is before this honorable court, my lord. He has challenged it in the IA. Let me file.
we don't find much justification.
Lordship, of course, lordship
When
will
can you
accept.
file it?
But today we will be filing it.
But then
Thought, my lord, any day, because the main case is, my lord, transfer. If that is sorted out, my lord, everything goes. Thought, my lord, only that point that he has been transferred from this particular institute to, my lord, the Jorat Medical College. This entire case is that, my lord, he has been appointed in the institute, not in a medical college, so he cannot be transferred. That's his case.
you are filing it today.
Yes, ma'am.
What date
Any
is
day,
convenient?
Thursday, Tuesday,
Next week, any day.
Tuesday, my lord.
As far as lawsuit convenient.
Yes.
Tuesday.
My lord.
Deep-
Obliged.
Is submitted by Mr. Boyd. If that by day. During the course of the day,
Yes, ma'am. I will file it during the court.
Yet on Tuesday,
Right.
has
Interim orders passed earlier.
interim order passed earlier.
Endeavor will be made to dispose of the requisition itself.
We'll see.
Roughly. Oh, right.
Deeply aware.
My lord, matter is relating to overdwell or excess service in service. So on the last occasion, my lord, one instruction was sought for. Otherwise, my lord, I am the grade 3 employee. The judgment of Rafiq Masih and another is Sibo Prasad Das squarely covers me, man.
Yes,
Lordship, we have the instructions sometime will be given to file the affidavit.
affidavit.
Yes.
He is what, a grade 3 or grade 4?
Grade 3, man.
Grade 3.
Yes.
You make inquiries and find out. The amount has already been deducted.
Yes.
Which judgment you are referring to? Rafiq Masih and
And this Honorable High Court, Sibo Prasad Das.
let him file the affidavit. Let us have the fact.
Welcome. Apart from this, also I have one office memorandum today, 31st of October 2012, issued by Commissioner and Secretary Finance. It says that those persons whose date of birth was entered initially at the service of period with the date of year in the matriculation certificate, because earlier in the matriculation certificate only age was there, date of birth was not there. So some things were there. So this office memorandum also states this to verify whose upon whose employment or whose services such types of errors are there. But nothing is done in my position, and my thing is also that in my birth certificate, matriculation certificate, only age is there. So some mistake was there. So that was traced out after my retirement, after handing over charge. So that cannot be done by the department without any, my lord, order or inquiry whether I was, and I made any wrong regarding my correction or my date of birth, my lord. But it is not actually totally legible. I can.
Let him file.
Well,
Then you, if you want, you can bring it on record also.
well,
He responded to the instructions from file after that. File next return. Daily bit for clear the matter of readings available. It's not first of like. You can take back the judgment.
May it please the Lordship, because this matter pertains to non-payment of arrears salary matter. The Lordship will see the earlier orders, madam. Several opportunities were given to produce the instructions, my lord, because the last several years, my lord, he has not been getting the arrear salary. Arrear salary is of for the period 2010 to 2012.
Lordship, in this matter, we need some time to complete our instruction. Kindly may give.
Arrear salary.
Arrear salary.
Fresh non-royal certificate not received.
No, Lordship. Instruction are every.
Right of it is being granted. If there is the response to the same place before the court, fail to apprise the court. As to why the DEO term has not issued the non-royal certificate. Or even the management for the prayer for prayer for further time. The court makes it clear that at the next day fixed, if his instructions are not forthcoming, then hearing officers may be directed to be present in court with all necessary reports. So, 15th of July.
Hello,
Yes.
hello.
Copy of this order be marked to the standing. Which department?
Elementary.
Elementary. For onward.
Hello.
Just now, respondent has filed a affidavit, sir. It's not on record. Next week, sir.
For appointment.
For appointment.
Next week. You are objecting to the appointment?
Yes, yes.
Require some hearing. The Mr. has Dekha appears to sir appears to the
Full response.
Mr. Gupta submits that the objections have been filed today.
Today, ma'am.
The registry will verify and I can say it's recorded by the next day. Based on Even your date.
Sir, forget me.
No, but you will have to obtain your instruction.
Yes, sir.
We don't see the matter being closed immediately.
Immediately after vacation.
By 18th of July.
Obliged.
Well, I need some 2 more weeks to file affidavit.
But on the last occasion, they have paid for filing affidavit, and this is the third litigation, my lord. Actually, arising out of the first litigation and the second litigation, I have withdrawn because for some fresh cause of action. Now here the
What
petition.
instructions do you want?
Actually,
The first issue that we are facing, my lord, in this petition is that multiple issues have been raised. My lord. They're challenging the PPO also. They're challenging some departmental proceedings. A lot of things are challenged, my lord. Let's see the prayer portions.
Actually, my lord, I have sent the expert inquiry report. Already, I have appeared before this honorable court. Expert inquiry report, my lord, on the basis of this, already an amount has been sanctioned regarding area salary. And subsequently, my lord, what happened? That they are not willing to continue the expert inquiry report is closed now. And he has been retired from his service. And they have collected, AGOB is collected by all the pension papers. But in the meantime, my lord, suddenly they have issued the provisional pension amount. They are going to fix the provisional pension amount as a regular pension amount. Then in the event of regularizing the provisional pension, my lord, then I will suffer irreparable loss on it. That is the first cause of action for which I am compelled to prefer this third litigation. And now my lord,
How much time do you want? Don't give a fake petition before the court that you want some time.
2 weeks, my lord, will.
2 weeks further time.
Yes, ma'am.
Let us give him 2 weeks further time.
no further time.
Further time.
So many times.
Forest.
PH, ma'am.
PH.
That may be fixed, my lord.
PH. Counsel for the petitioner. Seriously object. Raise the respondent. Ground that several drafted. Therefore, the next case submit that matter to hearing, given the objection, the affidavit. Hearing.
Arbor.
Yes.
6 and 7.
Very correct. Pension of the pension amount. Your issue is fixation of the pension.
Pension amount and also area salary.
Positive by the next. Third of July. That's all. 16th of July.
Yes, on that, my learned friend should file on that particular
We
day.
have ordered that.
Actually, yes, madam. Okay.
Obliged.
Possible.
My lord, in this case, I have received the instruction, my lord. I like to file affidavit, my lord. 2 weeks time may be granted, my lord.
Yes.
A date may be given.
As Dr. For PNRD.
Yes, my.
Submits that his instructions are complete. You like to report where made is by the council. Third.
R.A. Mazumdar.
R.
A. Mazumdar.
Yeah, appears on behalf of. Let's keep. Hope. This matter immediately after reopening on a date.
Lordship, for a date, your lordship.
On a date to be fixed by the registry.
File a plus.
May I please, your lordship? Lordship, section 11 petition, appointment of arbitrator, railways matter.
Lordship, affidavit we are filing today, Lordship. So it may be taken up on a Friday to process.
Friday.
Right.
It is submitted by Dr. Modi. That the objections have been filed. Why on Friday? Have you been served with a copy?
No, ma'am.
I am filing today, Lordship, not filed.
Tuesday, ma'am.
You may like to have some objections here. We don't know.
On Tuesday, ma'am.
Let the matter be listed again on Tuesday.
24th.
File your right.
Yeah, please about. Lordship, some amicable settlement was sought for and I have to receive instruction on that. Some amicable settlement was going on. I have not received the instruction yet. Lordship, after vacation, any date.
Yes. It is submitted by Mr.
M. Gogol.
M. Gogoi, counsel for the report that some applicable settlement is being sought, is being attempted to by the parties on the court. He therefore submits that sometime be granted to rise the court such settlement that may be arrived between the parties. If prayer is not objected to by the counsel, the petitioner lists this matter after 6 weeks.
May I please, your lordship? Lordship, in this matter, we have submitted our reply against the affidavit in opposition, lordship. Now all pleadings are completed in this matter.
What is the matter about?
Regarding they have challenged the order, madam, where and then they have been imposed as price non, madam.
When did you file your reply?
Yesterday, lordship.
The counsel for the petitioner submits the reply affidavit, rejoinder affidavit to file. The same, however, it's since the pleadings are complete, will issue rule. Rule.
Lordship, my short prayer is relief may be considered, lordship, for the petitioner, lordship.
Your rejoinder affidavit is not on record. You have filed it yesterday.
Yes, lordship.
It has to be brought on record.
Hello,
It has to be brought on record.
After
that.
In this matter, lordship, parties similar situated persons case has been dismissed by this honorable court. Therefore, lordship, may for 1 week time maybe you can to find out the judgment, lordship.
Yes.
Yes, lordship.
You have a judgment. Do you have the judgment?
No, lordship, at this moment I have.
Count the joint request to be listed next week.
Next week.
Problems.
I think my affidavit today itself. My affidavit is ready, Lord. In fact, Lordship, the affidavit says, Lordship, the petitioner has not submitted his next to kin certificate.
First file it.
Lordship, I am submitting.
Unless you file it, it is not, we can't have it official.
I am filing.
Can't take official.
In the course of the day, I am filing.
Yes. Mr. Upadhyay and Upadhyay, irrigation department, submit that is filing the affidavit during Mr. Mia hearing for the submit that he may like to file a rejoinder. State affidavit. As maybe as supposed to be filed by the view of the matter. And the paper be listed in the month of August. Yes, sir. Your name? Your name? As a of PR appears for respondent 5 and Mr. D. Das appears on behalf of the 3. Ms. U. Sharma and Mr. Respondent. This is what mentioned.
Pension.
Kali mana the fixed date in the first week of August, minor. Family pension, non-family.
Family pension.
Minor.
First wife, second wife.
Legally married, second wife, minor.
You are the legally married.
Legally married, minor. After the decree of divorce, minor, of the first wife.
Then why do you say second wife?
This says, minor. Deeply obliged, minor. Kali.
That will be listed on 4th of August.
4th of August. Obliged.
Okay.
Tango Broda. Great question. Time allowed in this matter has come up after 2020. And my lord, earlier senior counsel, when I am lord, he was engaged counsel. I have to.
You are representing whom?
Bank of Baroda, my lord.
Bank of Baroda. What is the matter about?
Also, non-payment of back wages and violation of the judgment dated.
Your pleadings are complete.
Things are complete, my lord.
Pleadings having been complete, issue root matter be listed for hearing in the
So may I pray for date, Lord, sir? Because we have not been paid a dues, your lord.
will come for hearing in its own, in the hearing list. There will be no date. Yes.
Paper relates to some casual workers working under the forest department. They are seeking benefits under the Quendas case, my lord. I have information from my client that already 4th round of verifications of their credentials have been over. It not been filed till date, in my case. Other case, I don't know. 34 and 35. For 34 and 35, my
You are appearing for item
36.
36 to
সেইটো চাৰি গুচি নাছিল মোৰটো আছিল ঠিকন ডেকা
It is filed in your matter. 36.
This is Chikon Deka. 1576 2020. करी पूछने में की थी
Affidavit is filed.
Affidavit is filed. Very file कुछ नहीं. I have not received any copy, madam.
You take out a certified copy. Don't know. Give him a copy, extra copy.
They have not filed, madam. Forest department did not file.
It is by
Finance department.
Yes.
Finance is.
Finance department. I don't know, madam.
We do not have.
Well, they may be posted after vacation. In the meantime, they will furnish the copy of the affidavit.
These matters, the forest department has not filed their affidavit. Finance department. Filed their affidavit. What is the stand of the finance? Do you agree or disagree?
The last list we approved, it was about 229 lots.
in implementation, no?
229 आपने कर दिया था.
29 Okay.
I got 8 lots.
Your names are in the 229. No.
Outside it was subsequently submitted. In
Because
paragraph
develop-
8 lots, it appears some queries had been made to the forest department.
No response.
It appears no response.
Verifications have already been done, my lord. 4th round of verification recently they have
But whether your names have been forwarded or not,
forwarded. Our petitioner's name have been forwarded by each division. I have the information, my lord. But no affidavit is filed.
division is all right, but as a forest department as a whole, has it been forwarded to the finance or not?
I don't know. They will say, my lord. Forest department
Yes.
will say.
Finance department. Sorry, forest department.
Multiple divisions, right? And all of them will have to be verified whether they
It appears that forest department for some reason is lost in the jungle. In all matters. Why is that happening? I don't have your instructors, you are deep in the forest. No instructions are coming. Who is the officer responsible here?
There's a PCCF-led committee, man. They verified the eligibility. The names are forwarded by the division.
No. If you have received instructions, you choose not to bring it on record, it is your fault.
I'll take instruction. These cases were not listed for some time, my lord. I'll
It is hardly a ground.
take fresh instruction.
The last date in the order was on 27/1/25. So you can't say that they were not listed for a considerable amount of time.
I'll take fresh instruction.
Date may be fixed, my lord.
In all the petition, the forest department council seeks further time to complete the instruction. The finance department, on the other hand, has filed an affidavit where it appears that queries raised by the finance department to the forest department in respect of the names of the petitioners being left out from consideration, being left out from the lists which were earlier sent. And the reasons, therefore, are still awaited and the instructions are not being received. The forest department. Council for the forest department submits that he be granted further time in the matter to complete it. Considering the submissions made, to be directed to be listed again immediately after reopening on a date to be fixed by K. Sharma in item number 36. 36 or number 3. Placed accordingly here. Reopening. After reopening.
Right.
Please, your word.
Lordship, we have received one instruction only yesterday, Lordship, regarding the pension proposal in respect of the husband of the petitioner, Lordship. that is under process and the file has been endorsed to the judicial department for its views, Lordship.
How much time is expected?
Lordship, we have also stated in our affidavit that the petitioner's husband does not complete the prerequisite of 20 years of qualifying service.
That was looked in 1999. The petitioner has been.
Whatever instructions you have, you bring it on record.
Lordship.
The counsel for the government advocate is permitted to bring on record the respect of the pension proposal of the petition. Husband, late husband. He's still alive or he expired?
No, Lordship is here alive, but he is mentally ill.
Husband who suffers from mental illness has taken that these affidavit be filed within 2 weeks. from today.
Lordship, we have already filed the affidavit with regard to the 20 years of qualifying service that he does not complete. Lordship.
Let me
Only the judicial.
affidavit by the government. Bring it on record by additional affidavit.
Lordship.
That is
Since 1999, Lordship, they are not getting any.
within 2 weeks from today.
And when provisional pension also not been, Lordship, they've.
Let us have all these instructions
Lordship.
in place before we do a direction.
Lordship. Otherwise, they
2
are.
weeks.
They have
Lordship.
It will be
Sub-
listed
very
immediately after the opening on the date.
dead may be.
Immediately after reopening on a date to be fixed by the registry. Registry will fix a date. Yes.
Affidavit on the inspection.
What is this instruction?
My lord, we have already issued notification, my lord, accepting the petitioner's, my lord, voluntary retirement, my lord.
What is your prayer here?
My prayer is for release of salary since my joining.
And one of them say, prayer is this also, my lord, for voluntary retirement, my lord, with effect from 15 to 2022.
Without salary and regularization that period. It is specific clear, my lord. On that, Lordship directed to take inspection why she has not been paid salaries after joining on 3rd of July 2018. On that point, my lord, no inspection is there. On page 25, my lord, Lordship.
For that all, I have received it.
Why don't you read it out to us and tell us what is it?
Actually, my lord, this was one of the main prayer, my lord. That is why I have submitted the notification, my lord.
Yes. Yes.
The conclusion part, my lord, last page. Due to the existing engagement of Sri Bahauddin Laskar and the absence of any official release letter from NRC authorities at the time of the petitioner's joining, the petitioner was not assigned any duties in this office and therefore no salary could be disbursed. The matter has remained in the status due to administrative constraints and lack of vacancy. The factual position may kindly be placed. That is for my.
He was appointed as what? He was serving in which department?
He is serving in, my lord, he was placed, my lord, but the earlier employee, my lord, who was not released from that.
He was an employee of which department?
PNRD department only.
PNR.
Block
Yes.
development.
And said Bahauddin Laskar was also a PNRD department, my lord, but he was not released where he transferred, my lord.
Then?
That is why he, my lord, application was submitted, my lord, for voluntary retirement.
Page
She
25,
didn't join, my lord,
page 25, my lord, she
because
joined.
no place vacancy was
Page
there.
25, my lord, kindly.
Yes.
Accordingly, she joined on 3 July, July 2018.
So she joined, but this officer was also not released.
My lord, they should have reported me to my earlier position. They have nothing done. Where is my fault? How, where I am to go without any order?
That is not for us to answer now.
No, my
It's for you to decide at the time when you were not
my
allowed
lord,
to join in
my lord, my humble,
2018.
my lord, my humble submission is that they have to arrange that because they have accepted my joining, and now saying that and another my lord letter I am showing, my lord.
Or may I suggest, my lord, lordship, second prayer has already been considered, my lord. Lordship may remand back to the matter to the government, my lord, so that government can decide after going through all the factual things, my lord.
That is what we want you to answer.
Yes, ma'am.
You have not been able to.
My lord, I have
for
received
what-
this from,
why, how you want to resolve this in this issue.
my lord, we have received this from block level, my lord. Lordship may dispose of the matter, government will consider, my lord.
What consider?
My lord, after going through all the factual things, my lord.
What stops the government from doing it now?
My lord, these facts are not placed before the government, my lord. At now also only for instruction for the case, my lord, they have issued this letter, my lord. Because petitioner also didn't approach government in that time, my lord. She simply didn't go join, my lord. My lord,
No, she joined.
she joined, my lord, but
Where is the transfer order?
My lord, transfer order at page 21.
21.
In the interest of public service. Junior engineer Hailagandi is hereby transferred and posted in the same capacity of Sunai Development Kachar by Sri Bharadin Laskar, junior engineer transferred with immediate effect. Thereafter, my lord, he submitted a representation on 5/6/2018. Most respectfully and humbly, it is being brought to your kind notice that during the course of the compliance of the paper transfer order, the undersigned got a verbal information from a reliable source that the Bahadin Laskar Junior Engineer Sunai Development Block Kachar is entitled with entrusted with an NRC job, which may kindly be verified at your end and therefore may not be possible to release him by the competent authority of Sunai Block by violating prescribed guidelines.
That person who is he a respondent here?
No, my lord, his status I don't know because 2022 page 41 lordship another letter is there from the end of secretary. Page 41 lordship.
Yeah.
That is from Secretary Government of Assam Panchayat and Rural to the Block Development Officer. Sir, with reference to the subject secretary, but I am directed to request you to submit a formal report whether she
Page 41.
41.
41.
To secretary. The formal report whether Badin then Sunai Development Kachar presently at South Hailakandi Development Block Hailakandi.
What is the report?
That report now they are showing he is working. Whereas this secretary level letter is there, he is working in Hailakandi.
No.
Was engaged in NRC works or not? If yes, the period of engagement may also be mentioned.
Page 41 requested for some report.
Here.
Where is that report?
That my lord submitted the asked block development officer to submit.
So where is that? Was it submitted or not?
Block development is a reply.
Where is that reply?
Then my lord again similar my lord undersecretary to the block development officer. They have to submit this report video.
Page 43, my lord. This is from block development officer to undersecretary, my lord.
prior to 28/10/2025 and transferred from to another department. Now they are saying the Bahadin is working here.
Was any action taken against the other person for refusing to follow the transfer order?
My lord, actually, he was not released by the from the NRC works, my lord.
Then?
My lord, thereafter,
Then this transfer order should have been modified.
that was not done, my lord. That is the problem, my lord.
Then who is responsible for that?
Lordship, for this part, Lordship may fix the matter immediately after vacation. I will take proper instruction, my lord. For the salary part, my lord. How government will arrange, my lord?
The third counsel for the party. The petitioner's grievance is that with to a transfer order issued by the department. The order dated where is the transfer order again? Where is the transfer order?
It's 21.
First of June 2018, whereby the petitioner was transferred from Aklicheran Development Block Hailakandi and posted in the same capacity as junior at the Sonai Development Block Qatar in place of one Sri Bahauddin Loskor, junior who was also transferred, who was transferred to the place earlier held by present petitioner. In pursuant to the transfer order, the petitioner joined in a new place of posting and submitted the joining report, and which report is also acknowledged by the PDO by subsequent communication dated 87. The junior engineer in whose place the petitioner was, however, who accommodated the petition, joined in his new place of is treated by the state officer having been engaged in NRC work was not released. Go and join the place of posting pursuant to the transfer order dated 2018. Stop. Nevertheless, the petitioner being joined the state place of posting claim to have continued to render the service. The respondent department, however, did not pass appropriate orders on time the transfer order dated 1st of June by taking steps after petitioner to any other place. View of the fact that Prince Saudi Loskor never released notwithstanding the transfer of the data. The such circumstance, the petitioner was not receiving salary in a due labor. Thereafter, being represented as salary was never received. The petitioner submitted her application for the so since either her area salary or the application will be considered by the authorities concerned. By the state pursuant to the However, both question I given area fee that it placed before the by the they were the matter is called the standing council is placed before the committee notification is issued by the additional chief secretary here. Whereby the petitioner was allowed to proceed on voluntary basis. However, his order does not reflect the issue about release of the area salary stated to have no status. The on the prayer made by the standing this court permits specific question as to the claim of the area salary and steps required to be taken by the department for release of the same. And surprise the court. Is this matter again on the board? Meanwhile, in pursuance to the notification dated 9/6/2025, the petitioner permitted to proceed on voluntary retirement by observing court open. List this matter on a date fixed by the ministry after.
Hello. It will be on 17th of July.
After 4 weeks, some date will be given.
Okay.
Hello.
Need to. Yeah. Last order, I was required to obtain the records basically. In regard to page number 18, that is annexed 3, and page number 22 of the writ petition. Actually, page number 18, the DP, which was going on the first DP, as per the recommendation of the inquiry officer, he was been reinstated. And after that, lordship, in the same month, he retired. And as per page number 22 of the writ petition, if praise DP was sanctioned, lordship, as per the recommendation of the IAS officer, lordship, DC Nagaon. Now, thing is that, lordship, in regard to the lordship, yesterday I had a telephonic discussion with the ADC Nagaon, lordship, and it was informed to me that the first DP is still pending, lordship. The first DP is still pending, lordship, and therefore, lordship, I require them to provide the same instruction in written form, lordship, so that I can place it before the court. And whatever you do in regard to the
Lordship, kindly fix this matter at 2. Due to some medical emergency, my senior is not here.
So we also need some time to place the written instruction and record, lordship.
You renew your prayer at 2 p.m. 2 p.m.
May I please, Your Lordship, it's an arbitration application, my lord. In the last order, my lord, kindly peruse 21/5/2024, my lord. In para 4, my lord has referred name, my lord, for the appointment as a arbitrator, my lord, Honorable District Leader. The consent letter has been given flag. Why is the, my lord, consent letter of the, my lord, Honorable District?
In pursuant to the third council of the court, pursuant to the order passed by the court, right, dated 21/5/2025, the Supreme Court that the district and second judge are appointed as the full arbitrator to resolve the dispute and differences arising by and between the parties, subject to permitting the written letter. And it's prescribed under section 12. The written declaration is finished by Sushil Kumar by communication dated 3rd of June 2025, where he has expressed no difficulty, hardship, no difficulty or legal. He being appointed an arbitrator to decide the disputes and the differences arising by and between the parties. That view of the matter, the appointment of the Sushil Kumar Sharma by the earlier order dated 21/5/2025 is hereby confirmed. The Sushil Kumar Sharma or that district judge Assam will act as the sole arbitrator to decide the differences and disputes arising by parties with regard to the agreement.
My lord, 3/8/2019, my lord. Sale date, my lord. It's my lord, sale date, my lord.
Sale date.
Sale date, my lord.
Sale date. Dated 3/8/2009. Is enclosed as annexure 1.
Annexure, my lord.
One.
It's a one, my lord.
Huh?
One, my lord, annexure 1.
The one to be the parties will appear before the sole arbitrator appointed by the court within 4 weeks.
My lord, a date may be fixed, my lord, sometime post the vacation.
We are giving you 4 weeks.
My
lord. I'm deeply
For
obliged.
the order, the verdicts by this order be communicated by the registry to the sole arbitrator. Parties are also at liberty to place a copy of the sole arbitrator.
I'm deeply obliged.
disposal.
Deeply obliged.
My pleasure, Lord. My lord, there are two numbers of the petitioner's lordship, and they were appointed as the member of the Commission for Protection of Child Rights Act 2005. So, for 2 terms. So, some part of the salary and dues were not paid. Your lordship may please to take up the additional affidavit filed by the petitioner's lordship, dated 9/6/25, page lordship. Page continuation, page number 179, Lord.
Yes.
Lordship, para 12, page number 179. The Rajesh Sharma, he is the petitioner number 1. The amount is stated here not paid. And then the petitioner number is 2 is Dr. Nandi Gopal Goswami. The amount mentioned were not paid. So, my lord, this can be disposed of with a direction to the respondent number 1, Lordship, that the petitioner will file a representation along with the copy of the writ petition, Lordship, and they may consider and determine the actual payable amount.
Then why have you approached the court? If
Lord-
the respondent
Lordship.
will have to decide this matter on the basis of a representation, what is the point in filing such voluminous writ petition? Under what provision are you claiming your right?
Lordship, under section 20 of the Act 2005. which provide that lordship, what are, and read with the rule. Section 20, lordship.
As may be prescribed.
Section 20, lordship. Provide that salary and allowances of the chairperson and the member, the salaries and the allowances payable to and other terms and conditions of the service of the chairperson member shall be such as may be prescribed by the state government, provided neither the salary and the allowances nor the other terms and conditions of the service of the chairperson or a member, as the case may be, shall be varied to his disadvantage after his appointment. So, lordship, accordingly, lordship, this part of the salary and allowances, admissible allowances were not paid.
No, where is it prescribed by the state?
Lord.
Section 20 says terms and conditions of service as prescribed by the state government.
Yes, Lord.
So where is the prescription? Where was it prescribed by the state?
Annexure 4, lordship. Of the writ petition, lordship.
The writ petition.
Yes, lordship. Page.
Page 28.
Page 28, lordship. Annexure.
Then page 32.
Page 32, Lord. Salary answer, clause 9, 9, Lord. Section 9. Members are entitled to get as per the salary payable to the secretary of the department. In section rules है क्या है? Rules lordship 10 and 11 also deals with DA, compensatory city allowance. And your lordship maybe come to rule 16, which deals with the facility for convening lordship.
No, but on what basis are you calculating the salary? Page 179. You have given a lump sum after
Yes,
deduction.
yes, lordship. I have detailed in my affidavit, in my writ petition as well as in the
Then
additional affidavit also. Lordship, my submission is that if a petitioner may be allowed to file a representation, whatever amount they will determine, we will accept, lordship.
yes. What do you say about this?
Lordship, we have filed our affidavit, Lordship, and we have stated that they are not entitled to these things, Lordship. And we already have paid and are paying, Lordship, as per the rules, Lordship, which has come into effect from 4/3/2016, Lordship. In our affidavit, Lordship, in page 102, Lordship, 102, 103, we have mentioned, Lordship,
Paragraph number?
paragraph number 6, Lordship.
My lord, if I am not entitled to get anything, a speaking order may be passed and that will close the chapter.
Paragraph 6, we have stated, Lordship, that the chairperson and the members of the ASCPCL became entitled to enhanced salaries with effect from 4/3/2016 only. In this regard, it is to be stated that the salary details provided by the petitioners in para 5 of the writ petition are for the months of May 2018, July 2018, August 2018, and September 2018. Then on the next paragraph, Lordship, we have made a calculation, Lordship, which has already been released to the petitioner's Lordship. And on the next page, Lordship, continuation of paragraph 7, Lordship, in page 104, we have stated that the sitting allowances and cost of POL was not paid to the petitioner, as the Finance Department, Government of Assam observed that there is no specific OM/notification in the department which allowed payment of the same to the members of ASCPCR, Lordship.
Now, Mr. Roy, you are at liberty to withdraw this petition and file.
That liberty may be given, I will file.
So we'll have to record that you want to withdraw, not press the petition and file the representation before the authority. That we can.
If I am allowed to file a representation, a fixed time may be given to the respondent to dispose of my representation. That will serve the purpose.
But petitioners are appointed as the you are appointed as member.
Yes. I have annexed a notification
Both
of
1 and 2.
one
The
and
petitioner.
1 and 2. That notification I have annexed
Petitioner.
in the additional affidavit also. That your lordship will get.
Child protection.
Appointment notification of pages.
Assam State Commission for Protection of Child. After rendering their services for the term appointed, the petitioners claim that certain amounts are receivable from the respondent, which include the allowances as well as area salary and traveling conveyance allowance, as well as the according to the petitioners, the petitioner 1 is entitled to receive amount of the 59,65,409. And the petitioner 2 is entitled to receive 40,18,091. These figures are reflected in para 12 of the additional applicant file. Para. The respondent, on the other hand, have disputed the claim raised by the petitioner and have instead held that the amount payable to the petitioner have already been released and the same is rupees 6,96,806. Insofar as the petitioner number 1 is concerned, is 29,84,767. Insofar as petitioner number 2 is concerned, these figures are reflected in para 7, the affidavit in opposition filed by the respondent authority. Although the pleadings have been completed, the matter is still before the court. Submits that they would like to approach the authority by filing a representation ventilating their advances if permitted, and thereafter the authorities will decide the matter and pass appropriate order, and whatever claim the petitioners are found to be entitled to should be released without further delay. The submission made by the writ petitioner, counsel for the writ petitioner is not objected to by the counsel to the respondent. That view of the matter, this writ petition is closed without expressing any opinion on the merits. The view of the prayer made, the writ petitioner is permitted to file the detailed representation before before which authority?
Respondent number 1.
Respondent 1, Chief Secretary.
Commissioner and Secretary.
Respondent 1, Principal Secretary.
Commissioner and Secretary, Lordship.
Respondent 1 is Principal Secretary.
Prince.
Respondent one,
Yes, Lord.
respondent one, Principal Secretary to the Government of Assam Women Child Development Department. This to one. Within 2 weeks from today. On the representation being so filed, we say respondent number one, we pass appropriate orders and dispose of the representation within 4 weeks thereafter,
After hearing DPT.
after giving an opportunity to the petitioners of the party. Thereafter, if any amount is found to be payable, the same shall be released forthwith without further delay. It petition will accordingly stand. So, give up. Interim orders, if any, that dated pending eyes on
Obliged.
M. Acharya for respondents.
I'm respondent number 135.
P. Nayak for Finance Department.
6 and 7 also, Lordship, I am hearing.
Mr. 404.
Instructions as to the provisions of appeal, my lord, was called for. Instructions as to the provision for appeal. He was disqualified, my lord, in the medical examination. The issue that arose is that whether there is a right for appeal, my lord.
My instruction, Lordship, there is no provision of appeal, Lordship, after review medical board. And in the review medical board, he was declared unfit.
That is why I placed a particular, my lord, circular the other day. That the candidate gets a 15 days period time to file an appeal. And once that is filed, my lord, he has to be re-examined. And to that extent, my lord, we have annexed 2 other judgments of the Honorable High Court also. But in similar situations, my lord, the examination was directed, my lord.
In our affidavit also, Lordship, we are. There are
Is this on record?
My lord?
Is this on record?
No, my lord.
Bring it on.
My lord.
Bring it on record.
My lord.
They want.
My lord, my lord. I'll tell them, stop it.
Right. Bring on record. What is this? This is the notification.
This is a notification from the Ministry of Home Affairs.
Regarding the revised scheme for common recruitment of constable in package E in the CAPFS, Central Armed Police Forces and Assam Rifles and National Investigation Agency Secretariat Security Board to be conducted by the Staff Selection Board, Staff Selection Commission. The said notification is issued by the Ministry of Home Affairs and where clause
Page 10, clause 10, 8.5.
What?
Page 10, my lord, clause 8.5.
The clause 8.5, there is a provision for an appeal for a representation to be filed within 15 days from the date of rejection of the medical board. So, the counsel for the petitioner that in terms of this notification, the petitioner is entitled to be given an opportunity to file the appeal before the authority. So, let this additional affidavit be filed as directed, as permitted, bring on the court the same. At 2 p.m. at 2 p.m.
Please, Your Lordship, pass over the timing.
For appointment.
Appointment, my lord. My lord,
The
nothing severed.
objections filed.
No objection filed, my lord, but nothing severed in the matter. Your lordship may appoint. Your lordship may peruse.
So we'll take it up at 2 p.m.
Yeah.
Your lordship. Lord, 3 p.m.
Kindly pass over the matter for time being.
Time being at 2 p.m. 2 p.m.
Yeah, my lord. Reinstatement in service, lordship.
Hmm?
Reinstatement in service. Petitioner was
Yes, review.
suspended.
Extension.
Informal instruction, one of these review is not done.
Review not done.
Done.
Have to-
So that's the no
Any
written,
departmental proceedings initiated?
that is initiated by the, inquiry has been completed. That instruction, I am waiting for that. Nothing has been given. Just informal instruction is given me to that, that the review was not done. So they are asking the deputy commissioner to submit all the records of the, that was not received by the department.
So what is the status of the department? Any department proceeding initiated?
That instruction was just, I was taken, the instruction regarding the whether the review has been done or not. That
Is there any show cause issued?
Lordship, one notice was issued and accordingly petitioner replied, Lordship.
Very good.
Department proceeding initiated.
Initiated.
Look.
So what is the status?
That status, my lord, has not received by the department.
You get it by Tuesday.
Lordship, otherwise also, this petitioner was placed under suspension on 39/2023. Even then, our High Court's order is.
So that's right.
we
We
have
want to know what is the status of the disciplinary proceedings initiated. Let it be on next Tuesday, 24th.
Lordship, except the reply, nothing has been done. Petitioner was asked in a formal.
What is the status of the departmental proceedings? Have you filed any WS, anything?
Nothing, Lordship. I was asked to reply a show cause notice, and accordingly, I have submitted my reply. That is the.
So let us get the updated status by 24th positively, or we'll pass order. 24th is Tuesday.
Let it be on 24th.
26th is the
Let it be on 24th, Lordship.
25th. We can accommodate you for one more day. 25th.
25th.
Please
We'll
on
try my best.
25th, we'll pass some orders.
Lordship, let there be an
Let there be.
Let there be an observation.
Yes,
Lordship.
yes. Please on 25th, enabling the Standing Council Revenue to apprise the court as to the status of any departmental proceedings initiated against the and also as to whether any review of the suspension was undertaken by the respondent. Based on 25th, if the instructions as directed to be placed before the court are not forthcoming, consequential orders will be passed by. Yes.
Basically, Lordship,
Yes.
He's on the way, sir. He's on the way.
Take it up next week then. You are submitting something?
Yes, Lordship, basically in regard to page number 18, and page number 22 of the writ petition, Lordship, basically page number 18, which says that, after the report of the inquiry officer, Lordship, he was being reinstated, Lordship. And that is the 4/12/2017. And soon after that, Lordship, he was being referred. And as per page number 22 of the writ petition, Lordship, that the do hereby accord sanction to start new. This is the second departmental proceeding. Lordship, in regard to the yesterday, Lordship, I have one telephonic instruction under rule matter to cover under rule 21, Lordship. The first DP is still pending, Lordship. So, Lordship, I wanted to provide me written instruction upon it, accompanied with the records. So what the department do with the second DP? They will decide, Lordship. They'll put it in the written instruction. But thing is that, Lordship,
Will file the affidavit.
yes, already one affidavit has been filed, I think, Lordship.
On whose behalf are you?
The
Who are you
DC Nagar, Lordship.
DC no.
DC Nagar.
There's case. Take up it, report. Right. Right. File. Yeah. Weeks.
Wait, Pijala. This is a very clear-cut case, my lord. It's a case of suspension. There are 3 dates which are relevant, my lord. 30/12/23, the petitioner was suspended. My lord, within 90 days, show cause notice was issued. That was on 1/3/24. But no review has been done within that period. Admittedly, a review was done on, my lord, 28/6/24. Therefore, my lord, the principles laid down in Ajay Chaudhary, Deepak Mali and all these cases will come into play.
There is an office memorandum.
Yes.
Which apparently was brought in pursuance to an order passed by the court and in Ajay Chaudhary. There, the review is to be done within 6 months.
Lord,
after the disciplinary proceedings.
how can, my lord, my lord, end of the day, this Ajay Chaudhary is nothing, my lord, where a legal fiction is created by the statute, which has been highlighted. It is something like, my lord, if charge sheet is not filed within 60 days or 90 days, as case may be, then, my lord, a person is entitled to default bail. Same principle has been done, my lord. How that can be either enlarged or restricted by an executive instruction?
But he has to put a challenge to this, but this has not never been.
No, my lord, my humble submission would be, my lord, since the Supreme Court holding is a law within the meaning of Article 141, my lord,
Correct.
I don't think lordship will take note of that.
You are referring to para 21 of Ajay Chaudhary.
Yes.
Now, subject to correction, para 21.
Yes.
Contemplates two situations. Ordinarily, suspension not to be extended beyond 3 months.
Yes.
Unless charges are served.
Yes.
And if the charges are served, reasoned order be passed for extension of suspension.
Exactly. The second part was not done.
Within how many days or months?
It was done beyond 3 months. It was done on 28/6/24.
In terms of Ajay Chaudhary,
yes.
What is the parameter for extension of charge?
90 days, my lord.
From which paragraph? Do you read that?
Para 21, my lord. If our holding lordship is holding the decision, we therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period, that is 90 days, the memorandum of charge sheet is not served on the delinquent. If memorandum of charge sheet is served, a reason order must be passed for extension of the suspension order. That means within that 3 months or 90 days as the case.
That is not clear.
In my humble submission, it is clear, my lord, because it says currency of a suspension order should not extend beyond 3 months. If within this period, number one, memorandum of charge sheet is not served. Two, the memorandum of charge sheet is served. If the memorandum is served, a reason order must be passed for extension of the suspension order. My lord, if it is beyond 30 days, then my lord, this prescription will make no sense.
But
In fact, my lord, Honorable Supreme Court was borrowing this principle from my lord, section 167 of the CRPC.
correct.
And my lord, our own government of Assam circular says so, my lord. Our own Assam government circulars.
Where is that? Sir?
Yes, take it up on court. No, I come.
You are referring to which?
1 second, my lord. There is a manual of departmental instruction.
Yes.
Test. My lord, if your lordship would kindly come to 2.1.8 of that government instruction. This is part of the OM dated 5th of September 1979. Kindly come to 2.1.8.
Yes.
Suspension should be resorted to only in cases where major penalty is likely to be imposed. So for minor penalty, suspension need not be resorted. Charges and the statement of allegations should be charged within 3 months from the date of suspension, failing which government servant concerned should be now 3. In case where it is not reasonably practicable to prepare the charge sheet for service within 3 months from the date of suspension, and continued suspension of the government servant is considered necessary in public interest, the authority concerned should move the personnel department to administrative department before expiry of period of 3 months with a letter detailing the nature of the allegation and reason for which charges could not be pre-prepared, so that personnel department could advise whether any further extension of the period of suspension should be permitted or not. More or less same safeguard. And I'm told, my lord, in one of the judgment, a coordinate bench of this honorable court has dealt with this aspect regarding, my lord, Ajay Chaudhary and that circular prescribing 6 months.
There's a division bench judgment also.
Yes.
But it does not deal with the circular.
No, I think circular has specifically dealt by a coordinate bench, my lord.
Is it available?
In a judgment called Digonto Kolita.
Digonto Kolita.
Yes.
Is it available here?
Huh? Give
us the judgment if you have.
Huh. In fact, if your lordship would kindly have this Deepak Mali's case, which is much before my lord Ajay Chaudhary.
Deepak Mali is very clear, but
Yes.
Deepak Mali only issue is that it is with regard to CCA rules where the rules are very specific.
Correct.
And the,
No, my lord, subject to what your lordship may say, my humble submission is, my lord, both these exercise has to be completed within 90 days. Because that's why I said, if it is Sir,
No, the reason why I put that question.
yes,
Because there is a Supreme Court judgment, it is binding, there's no question of not
right.
understanding or not following it. You see, if 90 days is the cutoff,
Yes,
then matter would have ended if the direction was that review must be done within 90 days, irrespective of whether you submit or you don't submit.
no,
Charge-
if, no, my lord, I was just trying to persuade your lordship, my lord. If memorandum of charge sheet is served naturally within that 90 days,
Has to be.
a reason order must pass for extension of the suspension.
That's what I'm saying. So the essence of this direction, as you have interpreted, is that 90 days is the cutoff.
Yes.
Whether or not you submit the charge sheet.
Whether, yes, this is also a requirement. There are two requirements.
So the requirement is 90 days, not charge sheet.
Hmm.
Can this be read alone?
No,
That-
Lord, I would like to read it this way. In a case where charge sheet is filed within that same period, 3 months or 90 days, that will not suffice. What there is further requirement is there must be a speaking order whereby the extension order should be extended. Sorry, suspension order should be extended.
Therefore, that has to be done within 90 days.
Yes.
So essentially, is it that the apex court has laid down by holding that it is 90 days alone, whether or not you file the charge sheet? Because even if you file it,
Then also there is a requirement.
there is a requirement.
Yes.
If you don't file it, there is a requirement.
Yes.
So essentially, it is 90 days.
Yes. Essentially, it is review, which is a must.
Within 90 days.
Either in a case where you have served charge sheet or not.
Or is it a case that if the charge sheet is filed within 90 days,
then also,
then you may review, but there is no time limit.
no. Because why it can be subject to what your lordship may say, we have to consider it in the contextual phrase, Miller. There is a semicolon. If memorandum of charge sheet is served, naturally within that 3 months, a reason order must be passed for extension. And what is the extension? Extension has to be from the period of 90 days. Extension has to be of that period. So therefore, my lord, this exercise has to precede the period, within the period of 90 days. The use of the expression extension.
Because you have to read 21 with 22.
No, my lord, 22 is a different case. Why I am saying so? Now to understand 22, my lord will kindly come to paragraph 3. This the argument was made by the state in several cases, my lord. Now please come to para 2 and 3, then everything will be clear.
Yes.
Various litigation was fruitlessly initiated by appellant in the Central Administrative Tribunal, Chandigarh bench, as well as in Punjab and Haryana High Court, with which we are not concerned. The appellant asserts that since the subject land was within the parameter of wall of the Air Force Station, no physical transfer thereof has occurred. On 28/12/11, the appellant suspension was extended for the first time for a further period of 180 days. This prompted the appellant to approach the Central Administrative Tribunal, Chandigarh bench, and during the pendency of the proceedings, the second extension order was ordered with effect from 26/6/12 for a further another period of 180 days. The challenge to this extension did not meet with success before CAT. Thereafter, third extension of the appellant suspension was ordered on 21/12/12, but for a period of 90 days. It came to be followed by the fourth suspension order for yet another period of 90 days with effect from 22/3/13. It appears that the tribunal gave partial relief to the appellant in terms of his order dated 22/5/13, opining that no employee can be indefinitely suspended, that disciplinary proceeding has to be concluded within a reasonable period. CAT directed that if no charge memo was issued to the appellant before expiry of 21/6/13 of the then remaining period the appellant would be reinstated in service. My lord will kindly see, there was fourth extension which was supposed to be effective from 22/3/13. That means it will come to an end on 21/6/2013. That is why this CAT directed that fourth line of the para 3, CAT directed that if no charge memo was issued to the appellant before expiry on 21/6/13 of the then prevailing period, the appellant would be reinstated in service. CAT further ordered that if it was decided to conduct an inquiry, it had to be concluded in a time-bound manner. The appellant alleges that the suspension was not extended beyond 19/6/23, but this is not correct. The respondent union filed a writ petition before the Delhi High Court, contending that the tribunal had exercised power not possessed by it, inasmuch as it directed that the suspension would not be extended if charge memo was served on the appellant after the expiry of 90 days from 19/3/23, that is currency of the then extend suspension order. This challenge has found favor with the court in terms of judgment dated so and so. Now, what had happened, Lordship will kindly see, 22/3/13 was the last extension, and it was supposed to come to an end on 21/6/13. Charge memo was issued on 19/6/23. Am I clear, my lord? In paragraph 3, appellant alleges that suspension was not extended beyond a month, but this is not correct. Respondent union filed a writ petition before the High Court, contending that tribunal had exercised power not possessed by it, inasmuch as it directed that suspension would not be extended if charge memo was served or appellant after the expiry of 90 days from so and so.
No, therefore.
Yes.
Therefore, para 22 is that in the facts of this case.
Yes, because it was given as directed by the tribunal.
But then, that's what is troubling us.
Yes.
That if 90 days is the cutoff.
Yes.
And as rightly held in Deepak Malik, once it is not extended, it cannot be subsequently sanctified.
Yes.
So the original order goes and everything goes.
Yes.
But this 21 and 22 has.
No, my understanding is very simple, subject to what your lordship may say, my lord. Para 22 has to be read in the context of para 3, because the extension within that last extended period, charge memo was issued on 19/6/23, and last date was 21/6.
Correct.
It is in that fact.
So if it was issued, then also the extension ought to have been done after the charge memo was
No,
issued.
no, kindly see, my lord. So far as the facts of the present case are concerned, the appellant has now been charged with charge sheet, and therefore these directions may not be relevant to him any longer.
That's right.
However, if the appellant is so advised, he may challenge his continued suspension in any manner to the law, and this action of the respondent will be subject to judicial review. Perhaps what lordships want to say, reading paragraph 21 and 22 together, is there is no two requirement. There is one requirement of giving charge sheet. There is no further requirement of review.
No, I'm not saying that.
No,
The
it will
first
lead to that, my lord.
First requirement is you have 90 days. Either you extend or you file charge sheet. Once you give the charge sheet, then perhaps this 90-day thing may not subsist. You may extend it. And this,
But
if
you may extend it, but if you don't extend,
that's the question.
here is that ours is a case where it was not extended.
So therefore, perhaps an attempt was made by division bench of this court to explain this in, I think, judgment called Ajit Sonwal.
Ajit Sonwal. এটা কি আনা নাই নাকি আজি রেকিবউদ্দিন
Ajit Sonwal judgment, it has accepted everything.
Yes, yes.
And
No, my lord, I think lordships can take that view, my lord. Fact of the matter is it was not extended. So therefore it is fatal.
now here, charge sheet was submitted.
Yes.
Within 90 days.
Yes. And dates are very simple, my lord. Suspension is dated 30/12/23. Show cause was 1/3/24. and review was done on 28/6/24.
So I think this is a case may be covered by Ajit Sonwal
Yes, Ajit Sonwal. The DB judgment, my lord.
division.
Yes. (28/6/24). No, what has fallen from your lordships on conjoint reading of para 21 and 22, it needs to be considered
It can be considered,
regarding the second requirement.
cannot be considered by us now. But the question is, reading 21 and 22, it leaves some.
Actually, my lord, in Ajay Chaudhary, Honorable Justice Bikramjit Singh said the earlier approach was not to strike down. But for the first time, this approach was adopted. And that is why the Honorable Court says they have brought in the spirit of 167(2).
Suspension is not a punishment.
Yes.
But you are treating it to be a punishment.
Then it assumes the character of a punishment.
Exactly. Therefore, this period of 90 days or
In fact, my lord, with all respect, even our Assam government circulars are very handy. Those were of early 70s.
But this circular is again creating a problem, and Assam government is not referring to this.
Yes.
In fact, yesterday we questioned the Assam government if this circular
How
record.
can they not, my lord? These are all executive instructions issued by the state. They are bound by this.
They're bound by it.
They can't make any argument against this.
But that scope of 6 months, not 90 days.
No, 6 months. Yeah. My lord, our copy has any. I hand over the copy, my lord. Para 10, Mr. Nayak learned Standing Council PWD by referring to the decision in Ajay Chaudhary, more particularly paragraph 21. My lord, that is that Diganto Kolita. I'll give the copy, my lord. Submitted that time frame as mandated therein for the currency of a suspension order as 3 months is for situation wherein memorandum of charge sheet has not been served upon the delinquent. He further submitted that Honorable Supreme Court had not laid down any time frame for review of the suspension after issuance of a memorandum of charge sheet within 3 months so permitted for currency of a suspension. The precisely the view which your lordship was trying to advocate. Nayak Learning Standing Council, by referring to paragraph 22 of the decision by rendered by the Honorable Supreme Court in case of Ajay Chaudhary, has submitted that although in paragraph 21, law regarding fixing of a time frame for currency of a suspension was laid down by the Honorable Supreme Court, the petitioner therein, who was suspended in the year and the charge sheet was issued in the year 14, during the currency of the matter before the Supreme Court, no direction came to be issued. Well, this is, my lord, without reading paragraph 3, this 20. Now, eventually, my lord, after dealing with all the issues, having noticed the said decision pertaining to issue of prolonged suspension and law declared in the matter in case of Ajay Kumar Chaudhary and implemented by state respondents by the issuance of OM dated 4/2/2020, this court is of the considered view that respondent authorities cannot act in violation of the law laid down by the Apex Court in Ajay Chaudhary, and it being a law declared under Article 141 of the Constitution of India, would be binding on all concerned in the country. Para 26. The operative portion is in para 26. And lordship may also come to para 29, my lord, at page 18, para 29. The law as laid down by the Honorable Supreme Court would therefore mandate that a suspension order being issued, the currency of the same would not extend 3 months if within this period memorandum of charge sheet is not served on the delinquent. The second part of the law mandates that if memorandum of charge sheet is served, a reason order must be passed for extension of the suspension. Second part of the law declared by the Supreme Court cannot be read in isolation and has to be read in conjunction with the first part. Accordingly, it is to be understood that currency of an order of suspension, while not being permissible to be extended beyond 3 months from the date of its issue, if memorandum of charge sheet is not served on the delinquent employee, and if memorandum of charge sheet is so issued in the period of 3 months, the same must necessarily be accompanied with a reasoned order extending the order of suspension. In other words, either on the date a memorandum of charge sheet is so issued and or invariably on the date the same is served on the delinquent concerned, such memorandum of charge sheet must necessarily be accompanied with a reasoned order extending suspension of the delinquent. Effect of non-service of such a reasoned order on the delinquent and memorandum of charge sheet is so served would be that the order of suspension would cease to operate and delinquent officer employee would be required to be reinstated in service. Subject to correction, my lord, if the state has not preferred any appeal against this order, this is final.
This interpretation is good. You stop at para 20. But if you have to read para 22, you must, because it's a part of the same text. Then this interpretation perhaps may not be called for, because it gives a question mark that why of the fact of the circumstance where the direction held not be.
I think regarding para 22, what could have been said is, my lord, it was in the context of para 3 of Ajay Chaudhary. No, I've followed what is going through your lordship's
If
mind.
90 days is the cutoff, which is what is being interpreted in 29, then para 20 at best an obiter, but then even obiter is binding.
No, I've followed.
So that's the only issue. But perhaps the answer lies in Ajit Kunwar.
Yes.
The penalty made correct. But that leads us to the question of what is to be done to the OM. It must be read down.
It has to be read down, my lord.
But there is absolute radio silence from the government. They are not responding to the OM. All right. Anything to be submitted?
Regarding para 22.
Now tell us one thing, any appeal preferred against judgment?
No. To our knowledge, no, my lord. Subject, of course, they may have the complete information.
All right,
Regarding,
find out.
regarding para 22, one Supreme Court judgment was found to place the Justice B.R. Gavai and L. Lagasora. There are 2022
Which judgment?
Kollan Dumvali Municipal Corporation versus Sanjay Gajanan Bharat.
AR 22, na?
Yes, Lordship. AR 2022 SC 1618. Relevant para, Lordship, para 50 to 54.
50?
50 to 55.
Yes. Party number. Anyway, tell us.
Para 50. Insofar as prolonged suspension of the respondent number 1 is concerned, the respondent number 1 has relied the judgment of this court in the case of Ajay Kumar Chaudhary Supra and versus Pramod Kumar. I reported in 2018-17 SEC 677. Insofar as judgment of this court in the case of Ajay Kumar Chaudhary is concerned, though this court has deprecated the protected period of suspension and repeated renewal thereof, in the facts of the said case, this court found that since the appellant therein was served with charge sheet, the direction issued in the said case may not be relevant to him any longer. Insofar as the judgment of this court in Pramod Kumar IPS is concerned, this court has observed that there cannot be any dispute regarding the power or jurisdiction of the state government for continuing first suspended under suspension pending criminal trial. There is no doubt that allegations made against the first suspended are serious in nature. However, the point is whether the continued suspension of the first suspended or prolonged suspension is justified. In the said case, respondent number 1 therein was suspended for more than 6 years. This court found that no usual purpose would be served by continuing the respondent number 1 and therein under suspension any longer. We find that in the present case, it is the respondent number 1 who, though called upon to participate in the departmental proceeding, has on his own chosen not to participate therein. It is the respondent number 1 who has objected to initiation of the departmental proceeding by the commissioner on the ground of jurisdiction and refused to participate in the departmental proceeding. We therefore find that the respondent number 1 cannot be permitted to take benefit of his own wrong. In any case, this is important. In any case, we find that the issue of prolonged suspension will be taken care by directing the departmental proceeding to be completed within a stipulated period, but suspension of respondent number 1 would continue till then. In a result, the appeals are allowed in following terms. 1, 2, 3. The 3 is relevant. Subpara. The departmental proceeding initiated against respondent number 1 are directed to be completed as expeditiously as possible. In any case, within a period of 4 months from the date of judgment. The respondent number 1 would continue to be under suspension till the conclusion of the said departmental proceeding.
Sorry, what is that? Subsequent last sentence you read?
Last sentence. The respondent number 1 would be continue to be under suspension till the conclusion of the said departmental proceedings.
What is the name of
Said
the-
principle.
What is the name of the party?
Kollan Dumbi Valley Municipal Corporation.
Dambi Valley.
Dambi Valley.
Kalyan Dambi.
Kollan Dambi Valley Municipal Corporation versus Sanjoy Gajanan Bharat. GHA-RAT. That this been thereafter your lawsuit was also passed an order lawsuit, considering para 22 lawsuit.
All right. We'll continue with this hearing.
Milord, no, I think this is a judgment in the facts of this case. Certain observations were there. Milord.
The whole difficulty, Ajay Chaudhary is a judgment in the facts of that case.
This was lawsuit has passed this order, considering para 22 lawsuit.
Some gray areas are there, Milord.
No. We are bound by the law that you can't keep a person on suspension endlessly. There must be a reason. The reason obviously is either 6-1 or 6.
At times, Milord, the nature of charge also influences the decision-making process. If the charges are very serious, then Milord, court will not be very keen to interfere with the suspension. Those aspects are also there. That's why, Milord, this Assam circular is very clear. It says you resort to suspension only when major penalty is likely to ensue. That means that assessment you have to make. If end of the day, Milord, after putting a government servant suspension for 5 years, you censure him, then what is the point?
Is this a case of 6-2 suspension?
6-2.
Was he arrested?
Yes.
The 6-2.
6-2, Milord, yes.
6-2 is even unfortunate.
Yes.
Because only by virtue of your detention.
Exactly. And if nothing happens in criminal case, so that preponderance is always there, Milord. That I am innocent until I am proved guilty.
We'll keep it for Tuesday. 20. Any volume? No.
No, page number 2 go.
Party name? You point it out on the next day,
Sure.
on Tuesday. Please take it on Tuesday for further hearing.
Deeply.
For the last date, I was required to provide
Yes.
specific instructions on the only one point that the promotion basically lordship from ACS to IAS is not on the not in regard to that disposal of DP, but in regard to the eligibility criteria lordship. I have obtained the instruction. If lordship permit, I may allow to read. Now the Honorable Court has directed to clarify the grounds on which the petitioner's case for nomination to the IAS was not considered along with his best mate. As mentioned earlier, against the select year of 2024, there are 3 vacancies to be filled out from ACS officer for promotion to IAS cadet, in which there will be 9 officers in the zone of consideration. As per the consolidated seniority list as on 1/1/2024, Sri Hari Prasad Kora is much below in order of seniority, and therefore he is not amongst the 9 officers in the zone of consideration. It is to be informed that the petitioner belonged to the year 1993 batch of ACS. As per records available in this department, no officer of 1993 batch, other than the officers getting accelerated promotion by of reservation junior to Hari Prasad Bora, has been considered for promotion to IAS till date. As already stated by this department's letter 14/6/2025, the process of promotion of ACS officers to IAS against select year 2025, that is vacancies arising between 1/1/2025 to 31/2025, has not yet started. Whether the petitioner would be in the zone of consideration for the select year 2025 would be determined after obtaining necessary vacancy concurrence from DOVT Government of India. The process would start in the early part of 2026 as per administrative practice. So this is the thing. Okay?
No, my lord, this administrative practice, the last word is very important. Now, if I am found to be a person who has been, deprecated or, my lord, indicted by an inquiry, then they will not promote me. The matter is very simple, my lord. I am a joint secretary in the Department of Handloom and Textile. A recruitment drive was carried out, my lord, where certain irregularities were committed. I was appointed to.
You appointed the inquiry officer.
Yes.
And you
Now, because I, and my lord, if your lordship will kindly come to one page, which is very important, my lord. If your lordship would kindly come to page 28. Page 28 was the bottom. Now, this is the order by which, my lord, an inquiry by a joint secretary level officer was, my lord, ordered with the approval of the Honorable Chief Minister. Please come to the last para. It is requested that the allegations may be inquired into by an officer of the department not below the rank of joint secretary, and report may be submitted to this office with views of the senior most secretary within 3 weeks. That means the inquiry which I headed, once I complete the inquiry, it will be, my lord, verified by a senior most secretary of the department. Then only it will be sent to the CM secretariat. Now, if there was anything wrong, how can I alone be wrong, my lord, proceeded against? Why not the senior most secretary of the department? And I was not guilty of appointing anybody. I only made an inquiry. If there is something wrong, then this senior man must have pointed out. In any case, my lord, the disciplinary authority is not bound by my inquiry report. They could have disagreed with the inquiry report. So, my lord, where is the misconduct? They proceeded on a erroneous premises, my lord. There is no question of I having committed any misconduct while conducting an inquiry.
What is the status of your?
No, Lord, I have been punished.
Censure.
No. Initially, my lord, there was a reduction. Sorry, 1 second. One increment was withheld, Then I filed an appeal, my lord. In the appeal, my lord, it was converted into a censure. A censure is also a minor punishment. So it will affect my career.
Error number 16, Lordship. Page number 150.
Well, we are on a point whether the DP should have been initiated. Whether I am guilty of any misconduct. Well, if a learned magistrate passes an order, which eventually it is turned down in appeal, will a proceeding be initiated? And my lord, none of these appointees have been disturbed. The senior most secretary has not been touched. My lord, end of the day, it must be seen that the justice is done, my lord. That's why we are before a lordship.
What is the ground for non-recommendation?
Yes.
What is the ground?
There is no dispute that my juniors have been recommended. They're all, my lord, evasive replies are given.
The ground is basically, Lordship, that the party has not come because he is junior, Lordship, not clarified the ground. As per mentioned earlier, Lordship, 3 vacancies were to be filled up from the English 9 officers in the general.
Who were your juniors who were promoted?
My lord, if your lordship would kindly come
Yes,
to.
Lordship, we have mentioned Hari Prasad Bora is much below in the order of seniority. And he is not amongst the 9 officers in the zone of consideration. That is in regard to year 2024, Lordship.
If your lordships would kindly come to page 162, my lord, paragraph 9 of our affidavit in reply, while dealing with para 17 of the affidavit of the state. Para 9. That the statement made in paragraph 17 of the affidavit of opposition being wholly misconceived and baseless.
Yes, carry on.
Yes. The petitioner categorically denies and disputes the correctness of the same. In this regard, it is humbly stated that the petitioner belongs to Direct Recruit 93 batch of ACS, and during pendency of the departmental proceeding against the petitioner, all his batchmates have been given promotion. Even officers junior to the petitioner have also been promoted. At present, the batchmates of the petitioners are working in the grade of Secretary, ACS cadre to the Government of Assam, where the petitioner is presently serving as Additional Secretary to the Government of Assam. Further, had the petitioner been promoted, along with his batchmates of Direct Recruit 93 batch, he would have been placed as serial number 30 instead of serial number 70 of the ACS civil list, published in the month of March 25. Therefore, it is apparent that due to initiation of the departmental proceeding on flimsy pretext, the petitioner has been superseded not only by his batchmate, but also by his officers junior to him, thereby causing grave and serious prejudice. My lord, the government should come up with whole truth. What they are trying to project is, my lord, since my name is in 70, therefore I have not been superseded. But because of this proceeding, I should have been at 30. My lord, there are different stages. From, my lord, junior grade to senior grade.
During the period when the promotion was there,
Yes.
was your case under seat up?
No, that I don't know, my lord. They have, normally they should. No, my lord, there are different stages. From junior cadre to senior grade to, my lord, senior grade 1, then additional secretary, then secretary. Now they are referring to a position of serial 70. This because this I'm in 70 because while promoting to, my lord, the additional secretary rank, I was superseded by my junior. Whereas my batchmates have become secretary and I am only an additional secretary.
No, but have you challenged that promotion order?
No, my lord, what? No. There is no question. Unless I succeed in saying that the disciplinary proceeding is bad, I cannot challenge that. So the prayer for, my lord, giving me that relief would be consequent upon my.
We are trying to understand.
Yes.
This disciplinary proceeding ending in a censure.
Yes.
How does it affect your professional prospects?
Because, my lord, because all these years when the DP was pending against me, I was not promoted in time to the grade of additional secretary.
They should have been under seal cover.
No, yes, could be. If they can show, it's well and good.
Should have been under seal cover.
Exactly.
How can you deny the?
Actually, my lord, these are the issues which needs to be answered in, my lord, clear cut thing, my lord. These are, they have their own circular which says if a criminal case is pending or a DP is pending, that means post this stage of Milord charge sheet, then they must adopt seal cover procedure. The moment disciplinary proceeding ends, either the seal cover should be open or it should not be open. Then these litigations would not have ensued.
Censure is what? Minor.
Minor. The least punishment.
Basically, also, when in the year 2020, yes, he is out of that 1993, and in 2024, some of the vacancy error was. As per the seniority lordship, he was not under the zone of consideration. And in regard to say, the giving promotion to his junior lordship, we have already stated the lordship. No officer of 1993 fails other than the officers getting extended promotion by reservation.
See the record.
Lord, what my learned friend is trying to project is, unless I become secretary, there is no question of my case being considered for the IAS. Now the question is, I was superseded when I was not made additional secretary and secretary in time because of this proceeding. That they are not projecting.
But that promotion is not under challenge.
No, my lord, there is no question of under challenge. Question is, if I succeed in establishing that this DP is bad, then lordship will direct a review DPC.
We'll have to examine the record.
Yes.
Get the record.
Yes.
Dispose of record, yes, also you can get. That the record, yes, that why what the punishment of censure, that I can get in lordship.
No, not that. These two records we want. First is the DP record, and the other is
Regarding my supersession in the ACS itself.
the departmental promotion committee need to put it under seal cover at that point in time.
Yes,
Assuming the proceedings were under.
Yes, yes. Having regard to my averments in para 9 of the affidavit in reply, let them produce the record. That will be clear.
Yes, yes.
Again, how the council assisted by Mr. K. Mr. C.K.S. Purva, cabinet. The pleadings have been exchanged. The petitioner has received the departmental proceeding initiated against the which culminated in awarding a minor punishment. Case projected by the regulator because of the departmental proceeding culminating in position of minor punishment. The petitioner was not considered for review promotion to the next time. And the consequence were his nomination, the cadre of IAS has not been considered by the respondent authority. Although persons in the ACS cadre who were here have already been nominated. In view of the submissions made, this court would like to examine the report. Stop the government advocate will produce the report pertaining to the disciplinary proceeding, culminating into the award of minor punishment of censure, as well as the records relevant for promotion to which post?
Promotion from Milord within the ACS itself. That is from up to the grade of Milord, from senior grade to additional secretary and secretary.
The promotion is also
ACS senior grade 1
ACS senior grade 1
to the grade of additional secretary and from additional secretary to secretary.
Additional secretary and from additional secretary to secretary.
In respect of the 1993 DR batch.
In respect of 1993
direct recruit batch.
Direct batch. So,
the
report will be necessary to examine whether if the case of the petitioner was put in seal cover in view of the department proceedings which were indicated against the petition. Let this record be placed before the court immediately after reopening.
Deeply.
Admittedly, we have not filed one, but otherwise about the present it influx was because the agreement was terminated, my lord. Against which they have
Malon may come to page number 31. The
the
termination is
dealership
also
agreement
covered
was
in the
terminated, my lord.
arbitration clause.
They have silenced. The requisition was also dismissed, my lord.
That is a different case, Malon. Malon may see clause 19 at page 31. Malon. May I read?
It was not presented to the
May I
scope, my lord.
read? Any dispute or difference whatsoever arising out or in connection with this agreement, including any question regarding its existence, validity, construction, interpretation, application, meaning, scope, operation, or effect of this contract, or termination thereof, shall be referred to and finally resolved through arbitration as per the procedure mentioned herein below. Now, the termination is also covered in the arbitration. Now, the dispute or difference shall in any event be referred only to a sole arbitrator. The appointment and arbitration proceedings shall be conducted in accordance with scope forum of arbitration rules for the time being in force or as amended from time to time. The seat of arbitration shall be at Kamrup Metropolitan. Now, my lord.
Yes.
My lord, page 114, my lord.
In scope, my lord, is page, my lord, after page 20, my lord. First one is conciliation and second one is the arbitration. Yes, sir. Page 20. After 20, my lord, the two parts is there, my lord.
What is scope?
My is called, my lord, extending conference of public enterprise, my lord.
Yes.
My lord, at page 114, my lord. My lord, the dispute was referred to the territorial manager, my lord. They, without replying the same, my lord, they did not intimate us regarding the scope forum, my lord.
No, you said it was terminated.
Yes, my lord.
My lord, but termination is covered in arbitration.
Where
As
is
per
the termination order?
my lord.
This was it was the contract for
Is it
Running a petrol pump.
petrol pump.
My lord.
well, after issuance of so called, they have come for, my lord, section 9, my lord. Initially, it was stays, my lord. After we prefer an appeal, my lord.
My lord,
Are you
Stays.
filing any objections here?
No, my lord.
my lord, please see the page. Flag mark.
You filed an objection.
Yes, my lord. After vacation, my lord, any date, my lord.
My lord, the notice was issued in February, my lord, in this case. My lord, may see the page that has flag mark, my lord. Last 6 lines, my lord. The Honorable High Court. Lordship got it?
Yes.
The Honorable High Court by order dated 13/2/2025 directed that no adverse orders to the interest of applicant, that is you, shall be passed till next date of listing. The said matter was heard on 27/2/2025 when the Honorable High Court reserved the order but did not extend the interim order passed on 13/2. Miss Arbitration Appeal number 9 of 24 was last taken up on 5/4. On the said date, Learned Court directed that interim order dated 5/12 shall continue till the next date. From above, it is apparent that as on date, there is no order prohibiting BPCL from taking any action in pursuance to show cause notice dated 22/1. My lord, during the pendency of the appeal before this Honorable Court, the order was reserved. My lord, the same was not extended. The BPCL terminated the contract. But my lord, the termination is also covered in the arbitration clause.
But that order as well as the termination has been silenced by this by the petitioner, my lord. That was also
My lord, that
dismissed.
is a separate case. That was done in a writ petition, my lord.
I'll file
That
a
was
objection, my lord.
dismissed, my lord.
Arbitration agreement is to be treated as a separate agreement.
But they have not come, any. They have not submitted any application before the scope, my lord.
My lord, we had intimated the territory manager of the respondent authorities.
It is
At
the
page
agreement
1
itself, my lord.
They, without replying, they, without intimating us anything, my lord, they kept.
But it is in the agreement itself, but the scope is there, my lord.
So what is the procedure in scope?
He has to file an application before the
Page
after 20, my lord. This is
20 of this
yes, my lord.
scope.
First one is for conciliation, second one is
Page or rule?
no.
Page.
Page, my lord.
Page 20.
After 20, we again start from 1, my lord.
Huh?
My lord.
Yes. Arbitration rules.
Yes, my lord.
Which rule?
Now, my lord, rule 18, my lord.
Rule 18.
Yes. Page 9, my lord.
Yes.
Unless there is a provision in the agreement between the parties for appointment of arbitrator, the secretary shall notify in writing to the parties of dispute for 5 names from the panel and ask for nomination of the one common name as sole arbitrator within 30 days. If the parties fail to nominate the common name from the panel within the specified period from the date of receipt of the communication from the secretary, the secretary in consultation with the vice president shall appoint the sole arbitrator from the panel thereafter. The whole procedure has been the next matter here.
We had intimated the authorities, my lord.
So who is to intimate the secretary?
My lord.
But
Who will intimate
the
the secretary?
person concerned, my lord.
Huh?
Who raised the dispute, my lord?
Where is it referred?
My lord, Rule 20, my lord. Initiation of arbitration proceeding. Clause 1. Unless there is a provision in the agreement between the parties for initiation of arbitration proceeding, a party wishing to have recourse of arbitration proceeding under these rules shall submit a request for arbitration.
Who is the secretary here?
This forum has a secretary, madam.
The secretary. Secretary is to be appointed by the governing body.
Yes, madam. This page 2, madam.
Huh?
Page 2, madam.
Page 2.
Yes, madam. Then, madam, in next page, madam. Forum means the scope forum of constitutional arbitration. Then, madam, secretary M, madam. Secretary means the secretary for a timing appointed by the governing body and includes such other person as the governing body may nominate for carrying out the duties of the secretary under this rule.
These, my lord, they had to be intimated after receiving the notice of dispute.
File your objection.
Yes, madam.
Here. Let the objection heard. Let the objections be filed.
So the date may be fixed after vacation, my lord. They are taking steps to handing over the petrol pump to a third party.
It already handed over to the
No, my lord. Till date not.
ad hoc basis, madam.
File a section 9 application.
My lord, we had filed the section 9
It was allowed, my lord. We preferred an appeal. It was state, my lord. Against this, they preferred a commercial appeal. That was also dismissed, my lord. Against that, they have gone to, my lord, Supreme Court. That was also dismissed.
On 18th.
Yes.
Like.
Deeply.
Yes.
Maybe was. And you also kindly say page 21st, madam.
Page?
201. No, so page 18, page 18.
Yes.
Notice for online mutual transfer application. It is for information to all employees and staff under so-and-so that from now onwards, mutual transfer application shall be accepted only through online system in the self-help module so-and-so. No offline application. Now, general conditions, madam. And the undersigned reserve the right to reject, hold any application for greater interest of the public service if it is found not eligible. Then your lordship will enter 2. An employee can apply for cancellation of his or mutual transfer application before the processing for order through online system. No application for stay, cancellation of mutual transfer will be entertained after issuance of any mutual transfer order. Now you will also find the next mutual transfer order is page 20. That is dated 21/11/24. Date is there, madam, in page, last page, page 25. Date is there. That is 21/11/24. Petitioner serial number, next page, page 21, serial number 22, 23. 22, that might be respondent number 8, and 23, respondent petitioner. He is by the block program manager, present position so far 22, serial number 22. He was at Dubri, he was transferred to
Inamul Hussain.
Madam?
Serial 22.
22 and 23. 22 private respondent. 8. So his position is block manager. Then his present place of posting is my lord, Raniganj. and posted to Dhubri. And my position, I am at Dhubri, posted to Raniganj. Your lordship got it right. 23.
This was mutual.
Mutual.
Why?
He applied, in fact, he applied.
You agreed.
I agree. And he is there for last 16 years, he is there, right? 17 years old.
He is there in Raniganj.
Raniganj.
From there he is gone to Dhubri.
Dhubri, and I have already joined here, my dear Raniganj. Thereafter, what happened, my lord, your lordship will find several letters I have given because he used to move fast. He did not move, so I have given so many letters. Thereafter, your lordship, kindly see page 31. Dated 24/12/24. When I made a complaint that he is not complying, he is not moving, so I made an application to the officer. In response to that, officer, my joint director state is writing to both of us. Your lordship got it. Page 31. They got to comply the order of that mutual transfer. Both of us have been directed. Your lordship got it.
31.
Yes, 31. Reminder of the compliance of the order of the compliance matter. He was not complying, so I was repeatedly appealing to them. This is to inform you for order issued by executive engineer so and so, which mandates immediate implementation of the specific direction. You are hereby instructed to ensure full compliance with the said order without any further delay. Any deviation or non-compliance with this direction will result in strict disciplinary action, indulging but not limited to the withholding of pay.
Yeah.
So then, my lord, your lordship, page 43. Release order is also there, my lord, page 33. Your lordship at the page 33.
Your release order.
Yes.
Then
page 43, my lord, page 43.
Huh?
Page 43, annex 12, I have joined.
Unilateral joining.
Your lordship, it is accepted by the authority.
No, but the other gentleman.
That gentleman I received, he also came, but he joined or not, he handed work charge to me. This is there, madam, page 43, your lordship, this. Page 45, but he handed work charge to me. Page 45, left side, bottom left. I have handed work, all the above file and run to the new BPN, Ishfaqul Siddiqui, present petition. On 30/30, my lord.
Yeah.
That is important, my lord. 31st to 31/25. So I joined, I have taken over charge.
No, who is Shafiq Ahmed?
My lord,
Page number 45.
Ishfaqul Siddiqui.
Huh?
Oh, that is my lord.
No, you are, what is your name?
My name is Ishfaq Siddiqui.
Ishfaqul Siddiqui.
So the page 45, bottom left side.
And Inamul Hussain is the other person.
Yes, respondent number 8.
He has handed over.
Yes.
You have received.
Right. I joined. Then this came at page 46. That is
Cancelled.
cancelled. That original, that cancelled.
Then
This is the part of telling in this book, in this book.
what is the challenge? You want to go to Rani Bagan?
I have already gone. I have already joined. I am walking.
If this is cancelled, you come back.
Madam?
If this is cancelled,
Right.
you come back to your original.
Why, madam? Once you have accepted, then what is the cancel? I have joined. There is no adverse remark against me. Certificate is there, my lord. Yeah, I am working very well. I am discharging my duties very satisfactorily.
But this is a mutual transfer.
No, mutual transfer, but once it is accepted, my lord, it is there, my lord, guideline.
At whose instance is it cancelled?
That is, my lord, they say that because Raniganj is a very sensitive area and it requires very much experienced person. So that's why, my lord. Can it be a ground, my lord? He is resident of Dubri, I am resident of Raniganj. The place where he joined, that is that only they are going to move.
Yes. That's your case.
This is the my case. In fact, there is another aspect where my lad can go start. Actually, some inquiry is going on against him in that Raniganj. So much some inquiry remains incomplete. So maybe that he, at his instance, this might have been cancelled because to go there and to see that evidences are my lord, consider hot government.
Are these amendments made in the writ
That is not.
petition?
Annexer I have given in reply of it.
Who is for the private respondent?
No, I have annexed my lord. Inquiry report I have annexed in my reply, my lord.
Why did you cancel it after applying?
But
Huh.
the government, it's not even apply for cancellation. The government that initiates the process because they required my service.
Why?
May I, Madam?
Yes.
Here is a case, Madam, where usually the transfer orders are issued on public interest. Here is a case, Madam, where the transfer orders were issued, transfer order was issued, in fact, on mutual request. Then there is a policy. May kindly see page 18 for a moment. And it is a National Health Mission where issued the transfer order. They are employees of the National Health Mission.
Yes.
Lordship will see, Madam, notice for online mutual transfer application. So the notice was issued online, and they were requested anybody who wants to have a mutual transfer, Madam, they are there to apply. Lordship will see general condition number 1. The undersigned reserves the right to reject whole, any or all application for greater interest of public service if found not eligible.
Not eligible.
Now here, my lord, they since 2 persons, my lord, they want to, my lord, interchange their post, my lord, so they were allowed. Now, my lord, that doesn't mean that, my lord, tomorrow in public interest, now the public interest comes, that the transfer cannot be cancelled. There is no such law to say that, my lord, once the public interest is there, my lord, the transfer order cannot be cancelled, or more particularly mutual transfer. The lordship will see here, the order was issued of mutual transfer on 21/11/2024. This my learned senior friend has already placed it at page 20. Their name appears at serial number 22 and 23 at page 21.
Yes.
Lordship will see, my lord, district Dhubri. It is an intra-district transfer, not that, my lord, he has been transferred out of the district. Both are from Dhubri. They are two different, my lord, block PSCs, where, my lord, my lord, transfer has been made. Now, my lord, in November, the order was passed. Finally, Lordship will see, after all these, my lord, release orders were issued, and thereafter, the present petitioner, he says that he's joined in 31/2025. In fact, that is the day when the order of cancellation was issued. Lordship will see page 43. Page 43. This is the joining report of the present petitioner. When he came to know that, my lord, the transfer is going to be cancelled or the order has been issued already, he hurriedly joins on, my lord, 31/2025 at page 43.
At page?
Page 43.
Yes.
Lordship will see, my lord, here the signatory is the Isfakur Siddiq. He is the present petitioner. Date is, my lord, 31/2025. No time has been mentioned. And page 46, Lordship will find the impugned cancellation order. Now, in the impugned cancellation order, one line I would like to point out. Lordship will see it is dated, my lord, 31/2025, issued at 11:31 AM, my lord. Because the digital signature, the time is there. So, my lord, Lordship will see the order in reference to the letter number so and so dated 9/1/25. The mutual transfer of the following so and so are hereby cancelled. So there is a particular letter which is being mentioned here in, my lord. Pursuant to this particular cancellation has been made. Now, Lordship will find that letter in an affidavit that the NSM authorities have filed by the respondent number 3. It is running page number 87.
87.
87, it is a part of the affidavit filed by respondent number 3, annexure 1.
Yeah.
Now, Lordship will see, my lord, the address is to the Mission Director, National Health Mission, NSM Assam. Subject request for cancellation of mutual transfer of the block program managers of Dhubri. So, my lord, in the reference, number 1 is the transfer order. Then later is of 19/12/2024, one another reference. Now it says, I write to bring your attention and request to the cancellation of mutual transfer order of the block program managers of Dhubri as per the aforementioned reference order dated 21/11/2024. That is a transfer order. It is important to mention that the Joint Director of Health Services, come Member Secretary, District Health Society, Dhubri has already forwarded a request in this regard by letter dated 19/12/24. The said transfer involves the block program manager Raniganj block PSC, which is one of the most critical health blocks in the district, facing numerous operational and logistical challenges. A transfer at this juncture is likely to disrupt ongoing activities and adversely affect the health services in the area. In the light of the above, I kindly request your good office to reconsider the transfer order and approve the cancellation to ensure uninterrupted functioning of the health services in the Dhubri district. So, on public interest, this particular request was made.
Where is that letter on 1912?
1912, perhaps, not a part of the record.
That letter?
May I? I don't think perhaps not there. It is. And perhaps that letter is not a part of the record now.
I'm just curious, what does this letter, one letter refers to another letter?
Yes, probably that is the letter by which the Joint Director.
We want to see what is the public interest.
Well, I can, yes, I can place it. Yes, sir, I can place it.
How much time should Friday or Monday?
Monday, it will be on Monday. Yes, I will say sometime.
Relevant copies of the decision
Lots.
taken by the authority. It forms the basis of the
Page 87, my lord.
cancellation of the transfer order. The Standing Council will also produce the communication dated 19/12/2024, stated to have been issued by Joint Director Health Service within bracket Joint DHS, some Member Secretary DHS Dhubri, as is found mentioned in the communication dated 9/1/2024. Let the matter be listed again on Monday.
Well, interim order may continue.
Interim order passed earlier will continue the next 8 weeks.
Right.
Interim. Yes.
This is the case where a doctor from the BSF, my lord, was put under transfer to Agartala.
Anesthetist.
Anesthetist. And we had challenged both the parts. We had challenged on 2 grounds. One, that firstly, that
he was entitled to an extension for a year at my present place of posting on the ground that my daughter
You
is
had
in her
applied for some
Yes,
childcare.
my lord. And now when I applied for a year's childcare leave, what I have been given for the affidavit in opposition is a 90 days childcare leave, which is neither here nor there. Doesn't serve any purpose to me.
90 days, is it the maximum limit?
No, 730 days.
It has to be as per the
Lordship,
rules.
as it depends upon the facts of each case, and this is defense, and there is only one anesthetist in each composite hospital. She was from the date of her joining last 11 years, she was 7 years in Shillong and last 4 years in Guwahati. Now she was posted at Agartala, and the other person had already joined in her place of posting. Now, what I have stated in our affidavit, although she had applied for 365 days CCL leave, we at one go we can give only 90 days. That is what my instruction, and that is what is we have stated in our affidavit. We have not stated that we will never give her or something, but in one go we can give her only 90 days because she is the only anesthetist and this is the composite hospital. So it will not be possible to give 365 days at one go.
What happens for the 90 days?
What happens?
Then, Lordship, after 90 days, she may join for some time and again ask.
Leaving my children.
People were not asking. In the meantime, the
Lord.
90 days if you give a leave,
Lordship,
then if you the only anesthetic,
Lordship,
then your hospital will not have an anesthetic
Lordship,
for 90 days.
Lordship.
So what is the what steps be taken by the authority that in that interim?
Lordship, in that case, Lordship, maybe because it may be operations, etc., which could be delayed. It may be delayed, and some other arrangement, or they have to go for private hospital. Also, that may be. But difficulty is that she is the only.
Can I just point out how that situation is handled if there is no anesthetist in a particular? Each of the CRPFs, they send their general duty medical officers to different courses and get them specialized in certain fields, which has been done in the present case. The submission that someone has joined in my place is not the correct submission. Who has joined in my place? It is a general duty medical officer who has just finished the course and is yet to be certified as an anesthetist. The person who has now been sought to be projected to have been placed in my post. She is a general duty medical officer who is not a specialist in anesthetist. She has undergone a course of anesthesia under the force system, where they have a few seats reserved in the PG category. She has just given her exams, got the result and come back. She is not yet registered as an anesthetist. And in the force, number one. Number two, there is a policy, perhaps my learned friend doesn't know, which was under challenge in this court and in the Meghalaya High Court, where they have objected to general duty medical officers with specialization being posted as specialists. Today, a statement is made that she has been posted as specialist. This is a two-sided game they are playing.
That policy is under.
It is under challenge in the Meghalaya High Court. It was under challenge here. The person who challenged it, there was a stay order. The person who challenged it had retired in the meantime, and therefore we withdrew that writ petition. Otherwise, it was under challenge and there was a stay. So there is a policy which now allows general duty medical officers with specialization in anesthesia to be posted in any of the composite hospitals. And very well, there are hundreds of persons who can well be adjusted there in the entire CAPFs, because now the transfer policy is being considered as all the CAPFs, all the doctors in the CAPFs are being taken as one to be distributed among the other forces. That is what the Meghalaya High Court has ordered. That is the policy being followed. That is now being placed before this honorable court. Now, I'll just, because she started on the entire merit of the case, if Lordship allows me, their policy which they have given to reject my case for extension of a year. If I understood correctly, it was only because persons with children who are in the 12th standard can be considered for an extension of 1 year. That is what we had understood last time, if I'm not correct. That is the only thing. And class 10 boards children are not exempted. Therefore, class 10 goes and class 12 stays.
Now, if Lordship has the affidavit in opposition where they've given the policy for him. The policy they have given is at page 57. Lordship, right?
No, where is the page number? 57.
57. Their affidavit in opposition. Starts at page 57. Lordship, right?
Yes.
Now, this is where I was rejected because my daughter is in class 10 and the policy speaks of class 12. Where does it speak? Lordship, at page 58, clause E down below, 5E. At page 58. The last clause. Officers with school-going children or whose wards are to appear in board examinations, that is within bracket 12 They forget to read the first part. Officers with school-going children, that they omit to read. They read from or onwards. Or whose wards are to appear in board examinations 12th standard may not be disturbed in the middle of the academic session as far as possible. Now, my lord, the facts of my case. 14th of December 2024, before the current academic year starts for the ICSE, I make an application saying that my daughter is now going to class 10. I'll have to register her. This registration is not transferable. That Lordship will find. I've given the certificate. Lorships kindly have. Yes, at page 26 of the writ petition. My first application, Lordship will find, is at page 22, the handwritten. It is on the 14th of December 2024. I tell them to the Director General, with due respect, I wish to state that I, so-and-so, Commandant so-and-so, would like to request the extension in Composite Hospital, Patgaon for 1 year due to the following reasons. I'm living with my 2 daughters who are studying in class 8 and class 10 in Guwahati, and shifting their school at this juncture will cause immense disturbance and difficulty for me and my children. My husband is also a central government employee and is working as professor and HOD ophthalmology department in Negrim, Shillong. Due to proximity of Shillong to Guwahati, I am unable to manage my family obligations. I'll be extremely grateful to you if my request for extension of 1 year in the Composite Hospital is granted. Thanking you. Now, the transfer the Lordship will find in the next page, which was issued on 24th of March 2025. I'm at serial number 1. 24th of March. That is 3 months later. Another
page number
23. On the tabular part, Lordship at the top will find GHTY 245153, then OP, then CH, then FHQ. The date is given 24/3/2025. 3 months later, without any reply to my this representation, they issue a transfer. Lordship will find at page 25. I make an immediate representation on 26/2025. My daughter studying in, I'm reading at page 25, clause 2A. My daughter studying in class 10 and class 8 have already been enrolled for the academic year. A media transfer would disturb their studies, particularly for my elder daughter who's preparing for her board exams. The registration of ICSE boards were already done when my daughter was in class 9 at Sanskriti School, Guwahati, which cannot be changed as per the ICSE policy copy attached. Now, Lordship will find at page 26, the school says, this is to inform you that Danika Natung, daughter of Professor so-and-so and Dagji Dalum Natung, is a student of class 10 of Sanskrit in the Gurukul, possesses strong academic potential. She has been registered for ICSE 2026 board exam from Sanskrit the Gurukul, and according to ICSE norms, registration once done cannot be changed. She has already commenced with her class 10 curriculum and all the fees for the whole year has been paid for. Relocating to another place would indeed disrupt her studies at this crucial year and might be very challenging for her to adjust in a new environment as well as academically, socially, and emotionally. Now, what transpires is, my lord, even when people like us, we admit our children. Class 9 is the time when we register in a particular. This I have informed to them in 2024 that I need a space till 2026. Let my daughter come out. these minor orders, then Lordship will kindly find their policy, my affidavit in reply, Lordship will have for a moment.
First, tell us what policy
My lord, the policy for transfer is what? There are two policies, one on which I had depended and one on which they are depending. The usual policies for the central government is at page 33, my lord. I'm sorry, my lord, that is not the policy. The policy that they have given is, yes, at page 38.
Yeah.
This is the policy that they now adhere to while exchanging GDMO and specialist doctors between different forces. So the transfer which now they try to impose upon me for the stay order given by the Meghalaya High Court, it should have been only done with the approval of the ADG medical of the CAPF. In law, this transfer order is wrong. I am not trying to challenge that. I am not trying to impress that ground, because if that is brought in, all transfers are stayed. In fact, in Meghalaya High Court, my lord, an application had to be moved to restrict that part of the illegality of the stay order only to the petitioners before the Meghalaya High Court, because there was an overall stay.
You are referring to page 39.
39, yes.
Which
Per page 39, Lordship will find
number?
Serial number 1. To improve overall performance of composite hospitals and provide better patient care, the specialist medical officer will be posted in composite hospital of the same force or CH of other CAPFs. However, in case of exigency and operational requirement, the specialist medical officer can be posted at CAPF hospital other than CH in the same or any other force. The performance of specialists shall also be monitored, and if not found satisfactory, they may be shifted to other locations. And so, the proposal of posting specialist medical officers will be moved by respective director medical to DG of the force. The DG of the force will send the draft proposal to ADG medical in his comments and views. The Director General of the force will decide the posting within the force, taking into consideration the comments, views of the ADG medical, and issue final order. In case of interforce posting, if any proposed by the respective DSGs, the order will be issued by ADG medical after taking approval of the MHA. Their affidavit in opposition shows that the composite hospital also caters to CRPF personnel and battalions. Therefore, either the approval of the ADG was supposed to be taken, or at least the order should have been passed by the ADG of the MHA. Here, the order has been passed by the Director General. In law, this order, my lord, requires to go on the very basis, but then all the persons who were transferred along with me, the persons who have got no grievance against their transfers, even they will have to be settled, because the entire order will go. It will become an order by an incompetent authority. I was not arguing on that. The grievance of the petitioner is very limited. It is a period of 1 year extension. Let my daughter attempt her examination.
So under what provision are you exercising or asking for the right? The service is an incident of service.
It is.
Transfer is an incident of service.
Yes, their own policy. I am trying to exercise my.
That it is malafide or contrary.
Once they, kindly appreciate, once they say that it is under this policy that we are rejecting your representation because you do not fall under this policy. At page 58, what I had shown to Lordship, at page 58, clause 5E. Down below.
58.
Yes, this is what they're trying to depend on. Officers with school-going children or whose wards are to appear in board examinations 12th standard may not be disturbed in middle of the academic session as far as possible.
Now, when was the transfer issued?
March
25.
25. The academic session for class 10 starts in February.
That
So therefore, their emphasis that it is only class 12 students who will get that benefit is wrong. Any person whose children are in mid-session, school-going children are in mid-session, are required to be retained or not transferred out at that particular point of time. Now, my lord, if Lordship will have my affidavit in reply for a moment. Lordship will like page 89. Lordship. Policy regarding posting transfer of Deputy Inspector General Medical, IG Medical in Central Armed Police Forces, NSG and Assam Rifle. Lordships will kindly have the yes, page 93, para 20. Academic year of the school college going children as per practice prevalent so far shall be kept in mind while considering transfer of medical.
this is what policy? Earlier policy or present
No.
policy?
What they do is, my lord, till up to the commandant level, they keep one policy 2010. And for Deputy Inspector General, that lordship will find at page 57.
Which policy is applicable to you?
My lord, the
Which
policy,
policy?
page 57, they say is applicable to me because this is for officers. All the transfer and postings are governed by BSF tenure rules 2000 and subsequent amendments. In addition, the following considerations are also kept in. This is what they try to say. Now, for Deputy Inspector General of Police, Inspector General of Police, academic session, no transfer. Any person below them, my lord,
that you're not
no,
telling.
I'm challenging. I'm challenging to the extent that allowing it to only those officers and not allowing to other officers when the main concern to bring in that classification is the rational, but the object sought to be achieved is academic session of the children.
No, you are saying that policy at 57
yes
is applicable to all officers.
Officers, yes.
You are presently DIG.
I am commandant.
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 It is in the rank of?
It is in the rank of commandant.
Equivalent to?
Commandant is one rank. Commandant is, it is one rank below DIG.
Below the IG.
One rank below the DIG.
So this policy at 57 is applicable.
Applicable.
All.
Yes.
Including commandant.
Including commandant. And therefore it says officers with school going children.
Now you are saying that this policy at 5E
yes
is found to be applicable only for DIG and above.
It is applicable to me also. So therefore I should have been considered under that clause. My rejection has come under the or part. Or are to appear in board examinations 12. They say your child is not 12, so we reject you.
Which you are saying is applied for commandant and below.
Yes. No. What I'm trying to say is that this policy also says that all officers with school-going children have to be given the benefit of not being transferred in the mid-session. Respondents try to understand it to mean that only 12 standard children, parents of 12 standard children will not be given the transfer. So far as they try to understand it for commandants and all, it is if your child is in 12th standard, you get the benefit of not getting a transfer in mid-session. But I am trying to show to lordship.
Has it been rejected?
My lord, the rejection order has never been given to me.
Where is the rejection order?
Rejection order they have not annexed. I have only been communicated, which lordship will find at page 31. This is dated 29th of April. It says OP immediate from force headquarters to HQ SDG, commandant headquarters. Then it says CH Patgaon, Agartala and all, CH Jalandhar from first representation against posting lordship fines issued during ATO 2025, specialist and GDMOs, representations in respect of following medical officers received against decision posting order issued during ATO 2025 have been examined in detail but could not be acceded to by the competent authority. I remain at number 1. Concerned officers be informed accordingly. No further representation on the same ground will be entertained and relieve affected officers to join their new place of posting as per schedule under intimation to all concerned. This having come at evening, Lordship will find at the top it is 1700 hours, that is around 5 o'clock. I am released.
Where is that rejection order?
It is not there.
She herself had agreed to go, Lordship. No. Her later is there, Lordship. I thought also there, Lordship. That movement order.
Page 61, charge relinquishment.
Yes, Lordship. Relinquishment order, page 61. So and so have relinquished the charge of Commandant so and so Composite Hospital BSF Patna on 30 April afternoon, consequent upon my permanent posting to so and that is she had put her signature. Thereafter, she filed this file another application regard asking for CCL, Lordship. And when her CCL application was pending, she filed this in petition, Lordship. And an interim order was granted not to enforce the movement order. But Lordship, she is already drawing her salary from her Agartala Lordship for last month, and we have also stated that CCL we can provide only for 90 days. And from the date of her joining, she had served in Shillong for 7 years and subsequently for 4 years in here, Lordship.
All right. CCL means
Child care leave.
Child care leave.
Child care leave.
So we'll examine that issue.
And one part
I heard CCL as of now for 90 days.
No, another point my learned friend had told that the DGMO part, Lordship, that lady who had joined here, she had already filed order dated the signal dated 7 March 2025. She was posted and she had already cleared her MD in anesthesia from Defense Medical College, Pune, Lordship. And out of 10 composite hospital, Lordship, 5 specialists are available and another 5 as there are no such anesthesis. So they were sent for PG qualification. After they become qualified in their MD, they were posted. And this lady had joined here. And now she is a degree holder in PG anesthesis. However, the petitioner is a diploma holder. In fact, she is more qualified, the present person who has joined here. And CCL, that we have stated our difficulties, Lordship, that 90 days, we are not denying. She can opt for 3 times in a year. And 90 days, we are ready to give her at present. And we are not denying that we will never give her or something like that. But at the row, 365 days. And judgments, Lordship, many judgments are there, CCL also. But this says that it is depend upon the condition of the service. A teacher may ask for 365 days, but an anesthesia in a defense, Lordship, it is difficult to give it.
Now you have agreed to give her CCL 90 days.
90 days in a go.
Here on this aspect. Meanwhile, you granted 90 days.
No, that they have granted.
They have granted.
That they have granted. For 90 days I'm on. 90 days, they have granted it. On my application, they said we are granting you 90 days leave. I am insisting on 365, but once they've granted 90,
you avail 90 days.
I'm here, Lordship. And just one clarification I'll bring in, my lord. The statement that I have relinquished my charge, I made a specific averment in my writ petition that I was directed to relinquish my charge on threat, and it has not been denied in the affidavit file.
Lordship, my affidavit is not.
Your
My
is there.
one thing, Lordship. My affidavit is not the affidavit in opposition. Lordship asked me to place on record my instruction.
You file it.
Lordship.
You want to file?
If necessary, I have to file because it's a transfer.
You decide whether you want to
Lordship.
file or you don't want.
If Lordship is keeping it pending, then of course Lordship.
Because if we have to decide this issue of 365 CCL, we'll have to hear the matter.
Hear the matter.
As on date, she's enjoying her CCL leave.
This year 90 days.
Granted.
When?
From which date?
The date of issuance, Lordship. In that case,
They say
16th of May.
paper of extension, it's from 16th of May.
16th of May.
Which is 17th.
17th. 16th of May.
July, August. Up to
August.
I mean 14 or 15 August.
We'll have it in July, end of July. Done. This matter again. Right? Meanwhile, the respondents are permitted to file their scale contract. Every motor partner has the meantime stated by the respondent that stated at the part that the drafted CLP, child care leave in brackets here with effect from 8 years applied 16th of May.
No, not.
No, I applied earlier.
She applied earlier, but we issued on
With effect from 16th of May 2025 for a period of 90 days. That interim order is not required.
No, my lord, my movement. Otherwise, I'll be required to report that, giving everything.
CCL is there.
No, the CCL leave is there. I'm on leave, but my requirement to report there would remain. They would insist on that.
Drawing her salary.
They'll insist on that, my lord. That is
No,
what I'm
Lordship.
saying. The day I filed the writ petition is the day I was made to relinquish my charge in the evening.
All right, whatever has been passed.
My lord, I'm so obliged.
I'm so obliged.
Obliged.
Fourth week of July, it will come. You mentioned it, it will not be. Because you have to file your reply, your counter, and they may like to file a rejoinder, so all these things will have to be completed.
Obliged.
Yes. Yes, Mr. Das.
Malad, this is regarding, I'm sorry, Malad, I could not be present personally, Malad, because of my health issues.
From
Malad, regarding the
9625.
9625 order, your lordship may kindly see.
Yes.
I personally, that
Mr.
order, I have sought for the instruction from the judicial department. They submitted it, my lord, on 16/6, my lord. The proposal, whatever was submitted for their views, that has been given and it has been forwarded to the PWD department from the judicial on 16/6.
Now PWD.
16/6, my lord. I have signed out, my lord. 16/6. Today is 18, my lord.
You let you Friday.
I don't know, my lord. Friday. On Monday. Monday.
And let it be on Friday. This man is not getting provisional pension also, Malad. And
I know.
whether any case is there, that is also there. Whether any criminal case is pending.
Then let it be on Monday. Let give him one more day.
Yes.
List this matter again on Monday, enabling the Standing Council PWD, Mr. R. Or to complete his instructions as it is submitted by Mr. P. Gugoi, London. Additional AG appearing for the finance.
Yeah, judicial department, I appeared on the last.
Judicial department that the opinion sought for has already been rendered by the judicial department and the matter has been remitted back to the PWD
On 16/6.
on 16/6. The PWD, the Standing Council is therefore permitted time to complete his instructions. Is this matter again on 23rd? Mr. B. D. Das, Senior Counsel, is through BC, the Commissioner, Mr. R. Boro for the Accountant General. Accountant General.
Well, they are to also to apprise provisional pension, Malad, as per the last orders.
The respondents will also apprise the court, the status, the steps taken for release of provisional pension towards the petition.